person, but I'm seeming to get these interesting things. It's crazy.
Buenos dias all. Good morning.
Good morning.
Morning.
Good morning.
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 Good morning, everyone.
Hello.
Hope everybody is bright and bushy-tailed, ready to go on this beautiful Saturday morning in Arizona. I'm Don Stewart. I'm president of the Arizona Association of Independent Paralegals, and you just joined the first of what will be 4 planned webinars, continuing education webinars, mostly designed for certified legal document preparers. So welcome to our 4. Those of you that are members of our association know that we offer these webinars, or usually in-person seminars every year. And just like every other year, the webinars will be the last Saturday of each month, and starting with this Saturday. We've got a great lineup today, interesting topics. The objective that I always follow is I want people to, certainly hone their skills, but also hopefully learn new skills and learn about to maybe, possibly expand their practice. And ultimately, so we can all make more money and be more prosperous and serve the community better. So we have 3 presenters today. And by the way, this is a 5-hour class. So we're starting right now, and it will go till right around 1 o'clock. It might go a few minutes after over that. But our 3 presenters, our first presenter will be attorney Brian Locker. Brian is going to talk to us about, he's going to give an intro to the legal paraprofessional program. 1 second. Sorry, I guess we have more people coming. More people into the meeting. So let me start that part over again. What I was saying is that we have 3 presenters today, starting with attorney Brian Locker. Brian will be talking to us about he's going to be giving a presentation about, that's an intro to the legal paraprofessional program, or also known as the LP. So that is the new licensure program that the Arizona Supreme Court is now offering. He's going to talk about requirements, how to become an LP, the areas of practice that are permitted, the kinds of services that are permitted, and I'm sure other things will be of interest to us. Next up after Brian, and Brian's presentation will be about an hour. After Brian, we have Kate Otting returning. Some of you may remember Kate from a couple of years ago. She's, in my view, our local mediation guru. So she's going to talk about being a mediator in the state of Arizona, mediation skills, and related issues, and as it relates to us as document preparers as well. And then third, we have Rob Merrill. He's a certified legal document preparer. Rob is going to give a presentation on family law, divorce basics, as well as talking about quadros, qualified domestic relation orders. So that's our lineup for today. A couple words on participation. I'll have you all, and I'll ask you all to please keep everything muted during the presentations. At a certain time, if the presenter asks if they have any questions, or if you just have some questions, we'll do our best to accommodate that. We have quite a few people attending, So I'm not sure how much of an ordeal that will be to answer everybody's questions, but we'll do our best to do that. You can raise your hand, or you can use the chat feature, and we'll, I'll communicate those questions to the presenter, and we'll answer them best that we can. Lastly, and then we'll get started into the webinar. Just a couple words on verification. So the way we do these webinars is that throughout the webinar, at 3 different times, I will hold up a word, and this is, I'll call them a verification word, and I'll be holding up these words, and I'll speak them as well and spell them out, just in case there's any of you that don't have video that are attending. But you want to write down this word, and at the end of the seminar or after the seminar, please send me an email to AAIP Continuing Education at gmail.com, and that's the email that I sent all your invitations to. So you can just reply to that email if you'd like, and give me the 3 words, and in response, I will send you your certificate of completion. And that's basically all I have for the intro. And hopefully this will go as smooth as it has in the past year. We're still kind of getting used to this new process. Also, just a quick comment about the return of in-person web seminars. I hope that maybe March, hopefully for sure in April, we might be able to have at least one in-person and kind of a combo, an in-person as well as online webinar, because I know a lot of people would like to be able to kind of meet like we always have in the past, and so hopefully we'll be returning to that by the end of this season in April, and again possibly in March, but I would think that probably only April. So without further ado, I'm going to turn this over to our first presenter, again, is attorney Brian Locker. Many of you know Brian. Brian has presented many times to AAIP, especially in our in-person seminars. And let's see, I want to make sure that Brian, are you raring to go? I think I don't need to do anything special. Turn it over to you.
I am sure to go. I'm just going to mute you. All right, and I have spotlighted myself, so hopefully you guys can all see me. I hope everyone is doing well. Again, my name is Brian Locker. I am a partner at the law firm of Fowler St. Clair. We have offices in Phoenix, Scottsdale, Casa Grande, and more recently, I opened an office in Atlanta, Georgia, where I telecommute between both Atlanta and Arizona. The vast majority of my practice is still in Arizona, and so I always appreciate the opportunity to speak for AAIP. I interact with many of you on a fairly regular basis, so I always appreciate the opportunity to do that. Dawn mentioned it briefly. I want to go over it as well, though. I do appreciate, and one of the things I love about the in-person seminars that we typically do when we're not in the middle of a global pandemic, is the interaction that we have as we kind of discuss these issues. And I think that this particular issue even lends itself more to a discussion as this idea of the paraprofessional program that was just launched this month is likely going to elicit a lot of interest and questions. So at the top of your screen, you're going to see a little hand icon. And if you hover over it, it's actually going to say raise hand. And on the right side of my screen, I have a list of everybody that is here in the meeting. And so when you click that button, I believe you're going to pop to the top of my list and be highlighted in yellow that says that you have a question. And at that point, I can actually then unmute you and we can actually have a conversation without having to go back and forth with chatting via text or something like that. And so if that works, I think that's going to be great. So feel free to If something comes up during my presentation, please feel free, as you would at an in-person seminar. I'd love to be able to have some interaction. So with that, let me share my presentation with everybody here. Make sure this is coming through okay. All right, hopefully everybody sees that here. So I imagine, given the people that are here, all being, at least for the most part, certified legal document preparers, unless you've been living under a rock for the last year, you were probably aware of the fact that the Arizona Supreme Court has decided to adopt what they have termed a legal paraprofessional program. And that is going to be the subject of my topic today. The Supreme Court has approved and adopted an amendment to the ACJA. So we have a new section 7210 to the Arizona Code of Judicial Administration that sets out what is the new legal paraprofessional program. So I'm going to just go over that. The content of the presentation is going to be a lot of going through a statute. So that's why I think it's I would love to be able to have some interactivity as we kind of discuss these issues, because obviously I don't want this to be incredibly rote. So let me kind of go over briefly what we're going to be talking about today. I'm just going to briefly put the ACJA into context, talk about where 7210 fits into the overall structure. Obviously, 7208 is the statute that governs legal document preparers. They put it right up against that. And for good reason, because I believe that both the way that this came about and the way that they've actually set up the legal paraprofessional program, it is kind of a sister program to the Certified Legal Document Preparer program. And I think there's going to be probably, in my view, there should be a lot of interest from legal document preparers to consider moving over into the legal paraprofessional program, because it's going to give you some really interesting options to expand your practice, which would be really cool. So I'm going to put it in context. Going to dive into what exactly is a legal paraprofessional program, and then talk about the regulations that Arizona has put in place, the Supreme Court has put in place to kind of set up the boundaries. What the differences are between a legal paraprofessional program versus an LDP and a lawyer. It kind of fits neatly in between those two professions, right? More responsibility, more ability to represent individuals than you would as a legal document preparer, but still with some guidelines that doesn't make it cross fully into the realm of an attorney. So pretty cool stuff. So let's get into it here. The limitations of the CLDP program, or how did we get 7210, or the legal paraprofessional program, right? Because as everybody knows, right, and as an LDP, you are well versed in the limitations of the CLDP program. But under 7208C, we have when the LDP program was created, we have a statement by the Supreme Court that states what the public policy is of the Supreme Court, right? The court recognizes that there is a need to protect the public from possible harm caused by non-lawyers providing legal services, but that must be balanced against the public's need for access to legal services, right? And so when the LDP program came about, the Supreme Court said, look, there is a potential harm by allowing people to perform services that would normally be performed by a lawyer and having them performed by a non-lawyer. But there is a need in Arizona to allow people to have access to legal justice, people who know how to interact with the court, prepare legal documents, better than the average lay person. And so that's how the LDP program came about. Well, so the way that they did that for the LDP program, right, is they set out through 208 the fact that an LDP program, LDP can prepare or provide legal documents without the supervision of an attorney in any legal matter when that person or entity is not represented by an attorney. They can provide general legal information, but may not provide may not provide any specific advice, opinion, or recommendation to the consumer about the possible legal rights, remedies, defenses, options, or strategies. They can provide general factual information pertaining to legal rights, procedures, options available to the person in a legal matter when that person is not represented by an attorney, and may make legal forms and documents available to a person who is not represented by an attorney. And finally, LDPs can file, record, and arrange for services of legal forms and documents for a person in a legal matter when not represented by an attorney. Now, interestingly, what came out of this process of creating the legal paraprofessional program are some additional amendments to 7208. One of those being this limitation in what I just read about the fact that an LDP cannot prepare or provide services to people who are represented by an attorney. That is actually, and I believe it's going to be adopted. They're going to remove. At least this was the recommendation, that they remove that limitation. So even if someone is represented by an attorney, an LDP can continue to provide services, because the idea is that the Supreme Court wants to promote the idea of unbundled legal services, right? Where just because you may have an attorney doesn't necessarily mean that attorney has to provide all those services, right? There are services that an LDP or even a legal paraprofessional can perform at a much more cost-effective rate, but still have an attorney involved to some degree. And so that, I believe, is occurring, where the requirement that an attorney be, that if an attorney is involved in LDP can't perform services, that limitation is going to be removed. But there are significant limitations here, right? In 7208, the idea is that while they can be involved in quote unquote any legal matter, there are significant limitations. The fact is, you cannot provide any sort of legal advice. You certainly cannot provide any sort of representation, certainly not in a court. And so there are many things that an LDP can't do. But as the Supreme Court started looking at this, they started wrestling with the idea that there might still be additional services that can be rendered outside of the attorney-client relationship to allow for additional access to the legal system. So let's look, and so I just put this in here to show the roles and responsibilities of an LDP must be offered and performed consistent with the legal document preparer code of conduct. And what we'll see is in this legal paraprofessional program that is brand new, they've actually applied a separate code of conduct for legal paraprofessionals, and we'll get into that as we talk about the regulations. So why expand this program? And I kind of hinted at this before, right? Why even go down the road of creating a legal paraprofessional program? Well, the Supreme Court a couple of years ago created a task force on the delivery of legal services. The Chief Justice, Scott Bales, recognized the fact that there is additional potential opportunity in the fact that the LDP program has been, by all accounts, an unbelievable success in the state of Arizona. There's no doubt about it. The amount of people who have been helped by LDPs, especially in more rural areas, right? Northern Arizona, things of that nature, where there certainly are fewer options when it comes to legal services. The amount of people who have been helped versus harmed by LDPs is hugely disparate, right? The amount of harm that has been done by an LDP is vastly outweighed by the amount of good that LDPs have done. And so Scott Bales said, look, is there, I'm going to create a task force to say, look, what else can we do, right? Let's take a look at the LDP program, see if there's additional things we can do to improve that program. But at the same time, let's evaluate and provide recommendations about how we can expand that to provide additional services to people who may not be able to afford the services of an attorney. So what did the task force find? This was about a year ago, a little over a year ago. The task force came back. It was a mixture of the public, lawyers, judges. I believe there was a couple of LDPs on the task force. And what they came back with is they said, we think we should amend 7208 to allow LDPs to speak in court when addressed by a judge. So not in a representative capacity, but certainly if they are there, they can be in the room with a client, and a judge can have the freedom to ask the LDP questions if they are more familiar with the matter than the client, and they have the ability to speak, at least on behalf of themselves and the work that they completed, not necessarily in a representative capacity, right? Further define permissible and prohibited activities of LDPs. That's one thing that I know for some people have been a point of emphasis. The idea that the 7208 has many gray areas, right? What is and is not permissible. So the recommendation was let's go ahead and further define what is and is not okay for an LDP, and then remove restrictions that I mentioned before, LDP from assisting clients represented by counsel. And then finally, their main finding was developing a program to license non-lawyer limited license legal practitioners. This is the term that's commonly used in the United States, an LLLP, limited license legal practitioner, qualified by education, training, and examination to provide legal advice and to advocate for clients within a limited scope of practice. And what Arizona did is they renamed LLLP to simply LP, legal paraprofessional. And over the last year have developed this program, and the statute 7210 went into effect January 1st of this year. So 30 days ago, this is 30 days old. So let's take a look at it. The legal paraprofessional is defined by the new ACJA 7210A, means an individual who is licensed pursuant to this section to provide legal services without the supervision of an attorney in the areas of law and within the scope of practice as defined herein. So there's a few important terms, I think, within this definition that really stands out to me as being the most important aspects of the legal paraprofessional program. And so the first one is licensed pursuant to this section. So we're going to talk about what is the licensure process. How does one become licensed as a legal paraprofessional under this new section? The second one is legal services, right? What does legal services mean? Well, 7210 attempts to define what legal services are. Again, with anything, especially a new law, there's probably a ton of gray area here and a lot of things that are subject to interpretation. So I think there's going to be a lot of a lot of massaging of this law probably in the years to come. But the third part of this, if I can get it, there we go, is areas of law, right? What exactly are we talking about when we say in the areas of law, and then finally, and scope of practice, right? So these are the four areas that I want to focus on today to define what exactly this legal paraprofessional business means. And so let's get into it and start with this first section of licensure. So, and I'm going to talk about this in the context of an LDP, right? Because that's who is here today, right? So as I talk about this, I'm going to talk about this as if you are an LDP considering becoming a legal paraprofessional. And so let's get into it. So let's talk about the licensure. So 7210E sets out 5 requirements, well, really 4 requirements with an either or at the end of it to become a legal paraprofessional. And the first one is you have to take an examination for each practice area in which you want to provide legal services. And we'll get into what those are, but keep in mind that there are as many as 3 or 4 different examinations you potentially could have to take depending on how broad you want your scope of practice to be. You have to submit to a criminal background check. you have to submit to a character and fitness examination, and that's not a test. That's more they look into your past. And as far as I can tell, it is essentially the same character and fitness and criminal background check that every lawyer admitted to the state bar is subjected to. And so that is one of the first differentiators here between an LDP and a legal paraprofessional, where they've brought in essentially the screening process for a lawyer and said, you know, if you're going to be providing these services, we're going to scrutinize you as a person the way we would scrutinize any attorney asking to be admitted to the Arizona bar. And then finally, so in addition to the criminal background check and the character and fitness, there's going to be either an education component, being able to demonstrate you've had the requisite education to become an LP, or the requisite experience. And that's kind of an interesting thing where they are allowing one or the other, because there's a lot of LDPs out there who potentially have enough experience to be able to kind of skip the education component of a particular practice area and jump right into simply becoming licensed through examination and a background check. Alternatively, you can go through the process of becoming educated in a particular area and then taking the examination. So let's take a look at that, because I think that's going to be the part that is most interesting for folks who are existing LDPs, is what exactly do I need to do to make sure that I can be licensed? Well, whether you can take the education or experience route depends on whether you can meet one of these criteria. So let's go through it here. We've got education on the left, and it says you can have one of these things. You don't have to have all of them. You just have to have one of them. Either a paralegal associate degree. So typically that's a degree that results in like a paralegal certificate. Or a bachelor degree in law, so a 4-year degree that focuses in law. And the statute actually goes through what may qualify for a bachelor degree in law. And so there's some additional requirements there to make sure that you qualify for that bachelor's degree. You can have a legal paraprofessional certificate program completion. Now, this is a program that has yet to be fully created, but it is referenced in 7210 that basically the Supreme Court is going to have an entire basically educational program that is offered to the public that, once completed, will allow you to then sit for one of the examinations to become licensed as an LP, which I think is really interesting, because I think it's going to be, unlike these other options, much more tailored to people who just want to get, you know, the shortest distance between where they are and becoming an LP. And so we're all going to be really interested to see what the Supreme Court does with that. But it does reference the fact that the Supreme Court will offer a certificate program that is some sort of an educational. My guess is they'll probably partner with a local law school or something to be able to do this. You can have an MLS, a Master of Legal Studies, a JD, or an LLM. LLM is basically a master's degree after you get, if you're unaware, an LLM is a master's degree after you get a JD. You can go back for another 2-year program and get an LLM. So if you have any of those qualifications, you can jump directly into taking an examination. Alternatively, so let's say you don't have any of these things, right? But you've been working as an LDP for a very long time. Here is potentially how you could also get in and be able to sit for an examination just through experience. And that is 7 of the last 10 years you have spent in full-time substantive law-related practice, or it uses the word experience. And that has to include at least 2 years for each area of practice in which you want to be able to offer services. And that experience has to be certified by a licensed attorney, meaning that licensed attorney has to have been able to say that you in fact did complete that experience, and I think presumably that means under their supervision, right? And so this is, and Don and I kind of talked about this offline the other day. It was kind of a point of concern that, hey, look, That's great for all these paralegals who have been working in law firms for the last 10 years. But what about, what about LDPs that have been working independently outside the supervision of a lawyer for the last 10 years or 7 years, as the case may be, who want to do this? And unfortunately, for one reason or another, the Supreme Court has said, look, if you're going to sit for an examination based on experience, we want to be able to say that that experience was gained under the supervision or in close relationship with an attorney, and we're going to make that attorney, whoever it is going to vouch for you effectively in order to pass that threshold. So, in my opinion, my guess is for the vast majority of folks who are here watching this presentation, what is likely is that you will need to pick one of the options on the left column in order to sit for an examination. That being said, and there's another thing I was talking to Don about the other day, a paralegal associate degree is not a massive undertaking. The only thing that it requires under 7210 is that you have essentially it's essentially an associate's degree, but it only actually requires like 2 full semesters worth of classes, like 1 actual year. And I think what we're going to find in Arizona is you're going to have community colleges and vocational institutions offer a paralegal associate degree that is tailored specifically for this LP program because the requirements under the statute are not rigorous. It's something that you could complete in like an accelerated night course over the course of a few months. And so I don't think that this is going to be a massive undertaking once things kind of settle down and everybody figures out how this is going to work. I think this is something that is not going to be a huge deal. There's probably going to be some obviously cost associated with it, but it shouldn't be a massive deal. So that's the education versus experience component. And so all of those things together, right? We got the background check, the examination, and then the experience versus education requirement. That is how you become qualified to be licensed as a legal paraprofessional. And this is and it's important to understand that the Supreme Court recognizes this as a license. This is not a certificate. This is not a certification. This is a full-blown license to effectively practice law and is an exception to the unauthorized practice of law statutes that are currently in effect in Arizona. So let's talk about the next thing, the legal services. So what are we talking about? What sort of legal services are we talking about here? 7210F1 talks about authorized services. So what can we do? Once licensed, a legal paraprofessional can prepare and sign legal documents. They can provide advice, opinion, or recommendations about the possible legal rights, remedies, defenses, options, and strategies. And you'll notice how similar the wording is there to the LDP statutes that says exactly what you can't do, right? They are specifically saying this is now what you can do as a legal paraprofessional. An LP can draft and file documents. They can initiate claims. They can brief motions and prepare discovery orders for the court and modifications to order, presumably in the family law context. They can also appear before a court on behalf of a party, right? This is full-blown representation in court of a client in front of a judge, right? And I think, at least for me, one of the reasons I went to law school was the idea that I wanted to be able to stand in front of a judge and make arguments on behalf of a client. That for me was a very interesting and enticing aspect of being a lawyer. And Arizona has basically come in and said, we are going to offer non-lawyers the opportunity to do this exact same service in a limited capacity, but do this exact same service. You can appear in front of a court on behalf of a client and make argument. You can also negotiate legal rights or responsibilities for a specific person or entity, meaning you can actually engage with an opposing party on behalf of your client to negotiate an outcome and a settlement, right? So not only can you go into court and you can make an argument that you presumably have drafted in a motion for a judge, but you can actually then interact with other lawyers and non-lawyers to argue on behalf of your client outside of the courtroom to negotiate resolution, which is you've basically defined my job on a daily basis. And so just a really interesting opportunity here for folks who love this area of the law and want to be able to do these, provide these kind of services. So that is what 7210 defines as quote unquote authorized services for an LP. So we've got legal services down. So now let's take a look at areas of the law. So where can these services that we just defined, where can they be provided? Well, 7210 F2 defines the areas of law as family law, obviously a need, right? I don't remember the specifics of the statistics that were released a few years ago, but basically, I believe it was in family law, it was some massive percentage of litigants in family law courts were unrepresented. And so this is a massive area of need. And so it is included here. Limited jurisdiction civil, limited jurisdiction criminal, and we'll talk about what limited jurisdiction means, and also administrative law. So for my practice, administrative law would mean appearance in front of, let's say, the registrar of contractors. So if you have a client that has an action against a contractor who did a terrible job or left the job or didn't provide workmanlike services, you can file a complaint with the registrar of contractors, and a hearing will ultimately result in the Office of Administrative Hearings. And that is one area that is part of the administrative law. There's many administrative law programs. That's just the one that I end up interacting with on a regular basis. But these are the 4 areas that are included in the legal paraprofessional program. It seems super limited until you realize that civil means basically anything, right? Family law is a massive area, especially for LDPs, right? And then also the criminal aspect. I don't know how many LDPs have a practice in any sort of criminal law, but including that is kind of an interesting idea as well. It looks like we've got a question from Marty. Marty, I'm going to go ahead and you're going to have to unmute yourself, but go ahead. Marty at the top.
Okay, it's
there you go.
Mary.
Oh, Mary, sorry.
Okay, it's Mary Corson. Okay, so would this include probate?
So, no.
Ah,
There is no. So the way that I read how they put the statute out there is they have the general rule of defining the what a legal paraprofessional can do, right? But then it's limited by, okay, it must fall into one of these 4 categories: family law, limited jurisdiction civil, limited jurisdiction criminal, administrative law. I don't see anywhere in there that actually says that you can appear in a probate court. I've got someone else chiming in. Maybe they have some different information as me, but I do not see where you can where probate court's going to be included in this, unfortunately, at least for now. So
okay, thank you.
You bet. All right, Martha, go ahead.
And what about immigration services?
So my understanding is that a lot of immigration law is handled within the administrative law courts. And so I personally do not practice immigration law. And so someone will have to help me out on that. I know that's a huge area for a lot of LDPs. But assuming that whatever you are doing in the in the immigration law realm is occurring within the administrative courts, that would be perfectly permissible. Otherwise, and in fact, here, while we're, let's see, Arizona. I'm just going to do a quick Google search and see if I get something. But Martha, do you know whether immigration law is under the Arizona administrative law courts or not?
No, I did family immigration. That's exactly court? No.
Okay. So the answer to my question, unfortunately, I wish I could be more specific, and I'm happy to take a look at this offline after the presentation to see exactly where most of the immigration law takes place, whether Arizona set up its own courts, in which case it would not be included in this list and not be permissible. But if it falls under either civil or administrative law, then certainly it is entirely possible that that will be one of the included services. So, Crystal, I see you've got your hand up. Go ahead.
So I'm assuming personal injury will work then, since it falls under civil.
Personal injury absolutely falls under limited civil. We're going to talk about, though, where you might run into some trouble. And I'm going to talk about what that limited jurisdiction means here in just a minute. And so if you still have a question about what exactly that means of personal injury, go ahead and raise your hand again, and I'll dialogue with you on that. But there is going to be some limitation on the personal injury side in terms of your ability to go into court and represent clients in court. So, but we'll talk about that. But yes, generally speaking, personal injury tort law, which is what personal injury is, falls under civil. And so that would be included. All right, Shireen, I see you've got your hand up. Go ahead.
Yeah, does this section, the 7-10F2, is that for LPs or is that for CLDPs and LPs?
Yeah, thanks for the question. That's an important clarifying point. So this is only for LPs. So what we're talking about here is a limitation on LPs. If you decide to go get this new LP license, you will be limited. You remember, in fact, I can go back real quick. We talked about these authorized services, right? And all these kind of expanded things that an LDP normally wouldn't be able to do, right? Providing advice, opinions, strategies, appearing in court, drafting and signing. I mean, obviously you can draft some documents as an LDP, but actually signing these documents and filing them with the court in a representative capacity, negotiate. What we're talking about here is if you want to perform these services as an LP, they are going to be limited to these specific practice areas. And you're going to have to actually take a separate examination for each one of these things. So potentially 4 separate examinations if you want to practice family law and civil. Then you'll have to take 2 examinations and so forth, right? So yeah, absolutely. If you are an LDP, this doesn't affect your ability to continue to do what you're doing within the scope of 7208. This doesn't have any effect on that. In fact, if anything, things have been relaxed a little bit. As I said, the task force had recommended that 728 be amended to actually say, even if your client is represented by an attorney, you can still continue to perform services as you normally would, which in the past you could not do. So, so these are the areas of the law, and so that takes us now out of the areas of law and into the final area, which is scope of practice. So what does scope mean? Well, so we've talked about all these things that an LP can do. We've talked about the areas of law in which an LP can perform all these authorized services, right? But what about how far does this go? Are there any limitations within these practice areas that can't be performed, right? So that 720-210F2 says, and we're just talking about family law here for a second. Under the family law practice area, even if you're an LP, what you can't do is represent any party in a matter that involves a qualified domestic relations order, so a quadro, and supplemental orders dividing retirement assets. For whatever reason, the Supreme Court has determined that because of the complexity of these things or the implications of them or whatever the case may be, they've excluded that from the family law practice area. And so even as an LP, these are not services that you'll be able to represent someone else in. Second one is division or conveyance of formal business entities or commercial property. So you can certainly in most divorces in Arizona, it only involves the division of personal property, right? And so that's not a problem. But if there are businesses that have to be split up, closely held companies between a husband and wife and that sort of a thing, there's going to be limitations there. And then you cannot represent clients in an appeal to the Court of Appeals or the Supreme Court from an order arising out of family law, the family law courts. Mary, I see you got your hand up again. Go ahead. Or Mary, was that from earlier and you? I just forgot to put your hand down. Here, I'll go ahead and lower your hand. You just have to unmute yourself, Mary, if you got a question. All right, Ella, Mary, I'll come back to you. Ella is, it looks like you've got a question. Go ahead.
I have two, please, Mr. Locker. So no, I am showing that I'm in a call. I don't understand what that means. I have a little red circle that says in a call, so I wasn't sure if I was able to speak, but apparently I am.
Mm-hmm.
Okay, if we were to pursue, if an LDP was to pursue a license as an LP, would we still keep our certification as an LDP? Because I do a lot of guardianship, estate planning, and such, which isn't covered under an LP license.
Right. Absolutely. I don't see any restriction on someone holding both a LDP certificate as well as an LP license. And so I don't see any problem at all under these statutes in holding multiple, both a license and a certificate and providing services under both. Now, yeah, absolutely. Yeah, obviously it's going to provide some additional, administrative hassle, right? Because, you're going to have separate, potentially separate continuing education requirements, license fees, all of that stuff. So you're maintaining two licenses, essentially. But yeah, certainly you can hold both at the same time. So, all right. So those are. So
Ryan?
Oh yeah, go ahead.
I've got my microphone now. I'm sorry.
Okay,
it's Mary again. It's on quadros. I can still prepare quadros, but I can't represent. Is that what you're saying?
You got it. So as long as, because as far as I'm concerned, there is no restriction on an LDP from preparing quadros. In fact, I know for a fact there's many LDPs that prepare them, right?
Yeah, I do.
Right, absolutely. Under 7208, I don't know of any restrictions for an LDP preparing them. Yes, you're absolutely right. It just would prevent you from acting in a representative capacity in an action dealing with the quadro. Now, yeah. So, and I think that's where there's certainly some gray area there, right?
Yeah, because I usually then refer them over to an attorney if there's an objection.
Right. Yep. Exactly. So.
Okay.
In any event, but yeah, I think you're reading that right. Is as an LDP, you certainly can prepare them, but as an LP, you would not then be able to go into court and represent the client on behalf of the client to advocate for it for whatever reason. I frankly don't get that, but I also don't prepare quadros. So, all right, Kimberly, I see there's a question from you. Go ahead. Kimberly, I see you're unmuted. You may have to assign your correct microphone for to be able to hear, so that we can be able to hear you, because I can't hear you. I'm going to move on, Kimberly. But as soon as if your mic starts working, go ahead and chime in, and I'll be happy to take the question. So go ahead and just interrupt me as I'm going here if you get it working. All right, so that's for family law, and obviously, if we want to talk about more of these family law exceptions, I'm happy to dialogue about that. Let's talk about the civil exceptions, and because this is kind of interesting for those of you that have a civil practice. Under 7210 F2B, Legal paraprofessionals may engage in the authorized services, again, that list of things that we talked about before, in any civil matter that may be or is before a municipal or justice court of this state. So that is the language of the statute, and then you've got my my interpretation is, in other words, civil matters with amounts in controversy up to $10,000 that are not brought in superior court, which is obviously a fairly significant limitation, right? For those of you familiar with how the Arizona court system, the civil court system is arranged, we have a tiered system of original jurisdiction for civil claims, right? So at the very bottom, we have our small claims courts that hear up to, I believe it's $3,500 in controversy, and that is administered by our justice courts. But it's a separate court within the justice courts that only hear up to $3,500. And it's super simple. You literally file the claim and you're in front of a judge within like 3 weeks or something. I mean, it is like real quick. And it's kind of the true like Judge Judy people's court experience, right? And then right above that, you have the actual justice courts that can hear matters in controversy up to $10,000. Right, and the justice courts are kind of split up between the justice courts, which are run by the county, Maricopa County, or Navajo County, or the other counties within the state, and then the municipal courts, which are run by the cities. Right, so you've got the Phoenix municipal courts and Scottsdale municipal courts, but they're all, generally speaking, they're all the same in that they all fall under these matters in controversy under $10,000. Now that's $10,000 exclusive of costs and fees, right? So let's say, for instance, someone wants to sue someone else for, $9,000, but it's going to cost them, $3,000 to hire you as a legal paraprofessional. That is okay, and they could actually still recover the full 9 plus 3, which would be 12,000, even though it's over 10,000. The 10,000 is only referring to the actual principal amount in controversy, right? So the amount of money that is owed from one person to the other, and it can go above 10,000 if there's additional fees and costs and stuff that take it over 10,000. So, but that basically excludes any case, in my view, that excludes any case that would otherwise originally require you to file in superior court. So these are quiet title actions, which is something that is a huge practice area of mine. So issues with title that need to be cleared up, that those have to be heard in superior court, and anything above $10,000, anything. And so circling back to the question we had about personal injury actions, right? If it's a minor personal injury matter, fender benders, soft tissue type stuff where you've got some doctor's bills and a little bit of pain and suffering and whatever, and you're talking about a total claim of $7,000 to $10,000. I think absolutely, this is not going to limit an LP from taking on a case like that. But unfortunately, if it's a larger personal injury action, I think you're going to be limited here because you would have to bring that action in superior court if your damages are above 10,000, and the LP is not going to be able to do that. Now, what my recommendation would be is if you generate cases in tort and personal injury, I would partner with a law firm to be able to basically arrange with them how you could continue to be involved in those cases. And if you do that already, you probably have an arrangement like that for cases that are larger. So in any event, so that is the limitation there. An LP is only going to be able to act in a representative capacity in civil for matters up to $10,000 and that are heard in municipal or justice court. So, all right, criminal. Legal paraprofessionals may render authorized services in criminal misdemeanor matters before a municipal or justice court of the state where, upon conviction, a penalty of incarceration is not at issue, whether by law or by agreement of the prosecuting authority and trial court. Now, this makes sense, right? Because if there is, in fact, a penalty of incarceration, that person has a right to representation by counsel a constitutional right, right? And so it probably wouldn't make a lot of sense to go out and hire an LP, or even hire, in some cases, even hire your own lawyer if a lawyer can be provided for you, depending on your financial condition. But for things like traffic tickets and other minor misdemeanor crimes, that is an area that that you potentially can create a practice around in the criminal realm. So that's it for criminal, and then administrative law. So the legal paraprofessional may engage in authorized services before any administrative agency that allows it. Which is kind of an interesting way to word that, right? I have no idea what they mean by administrative agency that allows it. I'm sure, there might be certain administrative agencies that specifically, pass an ordinance or, some sort of a statute that makes it impermissible. But in any event, legal paraprofessionals are not authorized to represent any party in an appeal of an administrative agency's decision to a superior court, court of appeals, Supreme Court. Again, just talking about this limited jurisdiction, right? They do not envision LPs representing clients past the original court that you bring it in this case, a municipal or justice court, right? Because there are appeal rights that a client has. If they're not happy with the decision in the lower court, in the municipal or justice court, you can appeal into either the superior court or the court of appeals. And at that point, an LP would have to turn over representation either back to the client or refer them to an attorney. So, Shireen, go ahead.
Can you clarify exactly what falls under administrative law for me?
So I'll do my best. So and as a caveat to that, I do not do a ton of administrative law. I gave the example before of the Arizona Registrar of Contractors, because that's what's most familiar to me and how I engage in the administrative law courts. But anything, any administrative agency. So this could be, another good example would be the Arizona Department of Real Estate. So if you are a licensed real estate agent and you have a complaint filed against you with the Arizona Department of Real Estate, and they take action against your license, that would be heard under the administrative law umbrella. Same with an LDP action by the board of by the board of licensure for certified legal document preparers. If they're seeking to have your license revoked, that hearing that occurs for that would all be under the administrative law courts. So typically, it's when you're dealing with a professional license, they are heard at the administrative court level. And so that's basically usually what we're talking about here. All right. Kimberly, I see you've got your hand up again. Go ahead if you got your mic stuff worked out. Go ahead.
Hi, can you hear me this time?
I can hear you fine.
Fantastic. I just want to clarify. So the legal professional license would not allow people to prepare legal documents. You can represent them, but you're not licensed to prepare the documents. Is that correct? So you would actually have to have both the LDP and the LP license if you wanted to prepare the documents and represent them in family law.
Okay, good question. The answer is you actually understand that incorrectly. So okay. Yeah, so thanks for letting me clarify. So no, if you have an LP license, you can both prepare and sign. So you can go one step in addition to an LDP, you can actually put your name at the top of the paper and sign it on behalf of your client, just like a lawyer would. Within these areas of practice that we're talking about. So it's limited in that sense. So an LDP can prepare legal documents in a broader, amount of fields. But as an LP, as long as we're falling under these practice areas, you can absolutely prepare as an LP. You can prepare and sign and argue these documents in a court of law. So you would not need both if you wanted to focus your practice in one of those 4 areas that we discussed for LPs. So, hey, Don, go ahead.
Brian, I just, since we're getting towards the end of the webinar, or your part of the webinar,
Yep.
I've been kind of acquiring some questions that people have been putting on the chat. And so I wanted to go through those questions, if that's
Absolutely.
okay.
Yeah.
Okay, so one of the questions is about getting your slides. Are you willing to share the slides and I can forward those to people that want them?
You bet. Because
Okay.
there's about another 10 slides that I'm not getting to, and I always prepare more than I have time for, which is my fault. So yeah, absolutely. I'll put a PDF together with all of these, and I'll send it to you, Don, and you can blast it out to everybody, because that's going to actually, there's some additional good information in here on the code of conduct. And kind of where things are really similar actually to where an LP will be like an attorney. And so I've got that in there. Folks can take a look at it afterwards and on their own.
Okay, so a couple more questions that were on the chat. One of them was whether or not you know where people can find more information or educate themselves about appearing before a court in family law issues or administrative area. And I don't know the answer to that question at this time. Are there any, classes you can take for advocacy classes or anything like that?
Yeah, so I would recommend on that. So if you choose to go down this road of becoming an LP, you're going to be required to take classes on advocacy, right? And so I think as they start developing these course curriculums for LPs, especially for the Supreme Court, it's going to be a little more clear what exactly the Supreme Court wants in terms of an advocacy course. But my recommendation would be, if you're super interested in this, I would go and I would audit a course down at ASU Law, or if you're in Tucson, down at U of A, audit a course on advocacy, trial advocacy. So because this is what you would potentially be doing, is trial advocacy, right? So learning about the rules of evidence, how to present evidence in front of a judge, how to argue motions in front of a judge, that sort of a thing. Unbelievably helpful. It would be I would go audit a course on trial advocacy at the local law school. I'm sure there are plenty of, I take continuing legal education online through an organization called Lawline, LAWLINE.com, and it's fairly inexpensive. You can buy by the class, and it's all just webinars. You can buy by the class, or you can just buy an unlimited license for like $179 for a year. And you can actually go in and there are a ton, hundreds of classes that would be on this exact topic. And so that would be another place to find good information about trial advocacy, if that's something you're interested in.
Oh, that's great. So a couple other questions. Can a CLDP be in a courtroom to answer questions for clients?
Yeah, that's interesting. So that is a gray area. What the recommendation for the modification of 7208 said was that it assumes that the LDP is in the room with the client, but it wouldn't be in a representative capacity. So let me tell you how I see that breaking down. If I don't see any problem with basically the LDP sitting kind of behind the bar, right? So you've got the table that the client would sit at, and then right behind is kind of the gallery, and the LDP basically sitting in the gallery. Certain judges may have a problem with an LDP sitting at the table with the client. But if a client like leans back and asks you a question during a hearing, and then they are the ones that ultimately speak to the judge, I don't see any problem with that. You're not acting in a representative capacity there. Where the problem becomes, and where the dividing line is between an LDP and an LP, is that an LP can sit right there at the table with the client, and when the judge asks a question, that LP can stand up and speak directly to the judge about that client's legal issue, right? An LDP cannot do that. An LDP could potentially confer with the client, but the client is ultimately the one that has to represent themselves if you're an LDP.
Yeah, the recommendation has not been changed in 7-208 in the LDP code though, right?
As far
So
as I'm
you-
aware, they haven't actually amended 7208 at that point,
Yeah,
at this point. Yeah.
So for now, I don't know, I might differ a little bit with what you just said. I would probably recommend, I think it specifically says that we shall not accompany people to court. I don't know if sitting in the gallery, you're saying sitting in the gallery isn't the same as going to court. Maybe it isn't. I'm not sure. I'd be cautious.
Right, and that's why I mentioned the idea of, you know, every judge is different, right? Certain judges are more hostile to the idea of LDPs than others. Some are you know, very supportive. Others are not, right? And so for those that are not supportive, yeah, that judge is not going to be okay with an LDP sitting there, probably even in the gallery, conversing with the client and providing input during the course of a hearing. They probably aren't going to be okay with that. Yeah,
but certainly, I know there are people, document preparers that have done this or had it done to them, however you look at it. But certainly, a judge can request that you come to court with a client. And I know I've not heard of this happening in Maricopa County, but in some outlying some of the other counties, I've heard of this happening, and maybe it has happened in with judges in Maricopa, where for whatever reason, the judge requested the document preparer be there to assist the client. If the judge asks it, obviously it's okay. And I don't know if there's a process where your client could say to the judge, motion the judge, ask the judge, hey, you know, can I bring my document preparer to be available in case, you know, I need help with providing you information or whatnot.
That's a great point, especially when, you know, if assuming they amend 7208 to provide the recommendation that says that an LDP can respond to judges' questions in open court. There is no problem with a client calling a judge's chambers before a hearing and asking what you just said, right? I've got an LDP that's been helping me out. Can I bring them with me? Is that okay? And then, you know, right off the bat, right? Hey, you know, either yes, no, that, you know, that's perfectly fine, or no, you know, the judge wants you to be there. You know, the judge doesn't want to have an LDP there. And then, you know, ahead of time. So I would absolutely recommend, if that's something that's interesting to you.
Just like two more little comments, then I'll let you wrap up and we'll have to move to the next presenter. But the other things to be considered with this new program that are probably too much to go into now would be, in my mind, you know, I wonder how like trust accounts are going to be handled. And I haven't read the whole new code, but I don't know that that's addressed in any way. And, you know, also insurance, you know, issues for LPs for the new thing. And then the other comment I just want to make, or I wanted to ask you actually, when we talk about administrative agencies, am I right to assume that would include the Corporation Commission as well as workers' comp?
Presumably, yes.
Okay, workers' comp could be a huge area.
Yeah, potentially. Yeah, and that's just an area I don't have. I don't even delve into. So yeah, but potentially that very well could be, if that is an area that is handled by the administrative law courts. Briefly, I do have a slide on here that you guys can take a look at offline. There are client trust account. Basically, the court adopted a lot of the attorney regulations for LPs, and some of those are insurance and trust accounts that you mentioned, Don. So there's going to be some significant regulations for LPs in those areas that you're going to want to be familiar with before you go down this road.
Thank you, Brian. That's all the questions or comments I have now.
All right. Well, as always, I always appreciate the opportunity to speak. Like I said earlier on, if you weren't here, I'm going to put a PDF together of these slides, and I'm going to send them to Don, and so he can distribute them to everybody, so you have them. And it's just kind of more of a cheat sheet than anything else on this stuff, because there is some CLE and professionalism regulation stuff that I wasn't able to get to that might be helpful for you folks in considering this stuff. So thank you again. If there's anything else that you want to talk about with me, I'm always accessible. You can always reach me. I think Don will probably go to a quick break here, and if so, I'll leave this slide up that has my contact information. Please always feel free to give me a call, send me an email. I'm always happy to interact with you guys and answer any other questions that you might have. So thanks again for the opportunity, and I'll turn it back over to Don.
Thank you, Brian. Yeah, please pull up that slide and we'll leave it up for a couple minutes while we transition. Okay, I don't see that slide up. Oh, there we go. All right. So yeah, please, as you know, if you've attended webinars or seminars here with AAIP in the past, you know that Brian and his law firm have been very supportive of document preparers. And so, you know, I have in my practice many times referred customers to them or clients to them, and that, you know, they've been very happy with their services. And so I highly recommend them and appreciate them. So, all right. Well, thank you, Brian. Now I am going to, let's see, I'm going to spotlight me and so I can get to the first word of the day. Let's see if that works. You're spotlighted. Okay. All
Sorry,
right.
you just have to turn the camera on.
Okay. Well, oh, I guess I got to turn the camera on. There we go. That'll help. Okay. All right. So again, thank you, Brian Locker, for a great presentation. You know, as evident, you know, by the presentation, there's a lot of opportunity for document preparers to possibly get into those areas, and I'm sure we'll have future presentations on the topic. So we're going to get now to the first word of the day. As I've mentioned, the first word of the day is horse, H-O-R-S-E. And you need this word. Please write down the word horse, H-O-R-S-E. At the end of the seminar or following the seminar, you'll need to email me the 3 words, the 3 verification words. And in response, I'll send you your certificate of completion. So again, that first word of the day is H-O-R-S-E, horse. All right, so we're going to move on to our next presenter, who I know is waiting. And our next presenter, as I mentioned, is Kate Otting. And I always like to say Kate is, in my estimation, is the our local mediation guru. I actually trained under Kate many years ago in family law mediation training. And although she'll tell you about it herself, she does many other things in the area of mediation and conflict resolution. Amazing person, amazing practice, and I'm going to turn it over to Kate now. Let's see. I guess I have to exit Spotlight and Spotlight Kate. So. Okay. Kate, are you there?
I am here, and my Wi-Fi just, of course,
there you are.
I
see you.
Yeah. As luck would, my Wi-Fi just kind of went in and out for a few seconds there. So hopefully that I won't have these problems. Can everybody hear and see?
No. It's all yours, Kate.
Okay, perfect. I'm going to share my slides here. There we go. Oh.
I see them.
Okay. You can see it. Perfect. All right. Well, thanks, everybody. And hopefully my Wi-Fi is stable to.
So Kate, as you said that, your Wi-Fi went out.
Okay.
Go
So you know what I'm going to do is, yeah, I'm going to turn off my camera because I think that might help with stability here. Apologize for that. I appreciate this opportunity to present to all of you. I was doing this a year ago, and really sick, and I had just had a former student of mine me from Taiwan, and then all of a sudden we started hearing about this COVID-19, and I'm pretty sure it's what I had a year ago. So thankfully I didn't expose you all to it. So I'm going to be back. Today I'm going to talk about strategies for managing everyday conflicts. This is something that presented a couple years ago, Don, was it? Either two or 3 years ago.
2 years ago.
Years ago, okay. So if you attended, some of this might be familiar, but of course, you know, I've had time to do some to make some updates, and I think last time maybe I presented for an hour. I have a little bit more time, so I want to do some exercises. You know, this is something that we can all incorporate in our daily lives, but I know many of you, if you aren't already mediators, you work with mediators at some point. This is, you know, this is just a little snippet of what mediators, Don, as you said, you went through the mediation training, some of what mediators will go through in mediation training. If you want a copy of the handouts, I've got them available. A special link that has to be lowercase AAIP. So imamediation.com/AAIP. Also, I am currently, so I run the mediation training online now. It's a long story if that happened. I started doing it just for one group that was overseas. And then the pandemic happened, and it has been wildly successful. I now have 173 people. I think, Don, I told you 100 yesterday when we spoke, and I actually looked it up. I have 173 people currently going through the course all over the world, practicing in simulations. So if you go to that link, you'll see that I have special pricing. The course is actually closed to the public, but it is available. I just opened it up because it can happen anytime. So I'm doing some fixes on the back end, but you're welcome to enroll at the course, and I've got special pricing there. So next, I want to just tell you quickly a little bit about me. My first language was Japanese, thanks to my parents. It took me there when I was, and then the Peace Corps, and lived after I became a grad student studying international development. So how I ended husband. Oops. I think my Wi-Fi went out again. Okay, there we go. Ended up at the Iowa Peace Institute because I had to do this international internship in conflict and development. It was a Peace Institute, was a public ship, and I never planned to be a mediator. And then I realized living laboratory, you know, I could really work hands and teach them mediation, learn from them as well. Eventually, I ran the Attorney General Mediation Program, and I was also an ombuds for the Arizona Legislative Council. Then quickly, I married that's my granddaughter, because I have to throw that in. Those are my sons now. And then I'm working on my PhD in conflict and development at a university in South Africa. So my focus is on the conflict in Sudan, but I am based here in Tempe, Arizona, and my clients now are from, like I said, from around the world. About my company, Interaction Management Associates. So we have conflict engagement services, work primarily with public sector conflict. We do conflict analysis, mediation, coaching, conflict management, conflict engagement, some public policy, policy review services. We also train, as I said, 40-hour mediation training that culminating in a certificate of mediation, which it usually will satisfy CLE requirements as well, and some quite a bit of advanced training for mediators. So a little bit about, you know, the topic of this is strategies for managing everyday conflicts. So in terms of conflict management, if you look at no single definition of what conflict management is, most of you have, you know, I liken it to the field of communication, right? So it's not isn't quite as gray, and the mediation field is largely self-decided, partly because there are so many unique practices in the field of conflict management. I apologize for Wi-Fi. I contracted with Cox and got the best service I could probably get. And so if you take a look at alternative disputes, you
Kate, sorry to interrupt. I have a suggestion.
Absolutely.
I don't know if you have this, but if you have a hotspot on your phone, it may provide you with much better connection. I don't know if you ever
Okay, I
use
will
that.
try that. Yeah, I do. You know, generally don't have this problem. It's that Teams, if Teams uses a lot more bandwidth. Let's see, personal hotspot. I just haven't had.
It's okay. It's okay.
Yeah. Let me see. Hold on just a second. I'm going to have to get out of this for a second. I know this is very frustrating.
I did that this morning. I'm broadcasting through my hotspot instead of the Wi-Fi, and I haven't had any problem. Knock on wood.
Okay, great. Well, I am on now. So thanks everybody for being with me. I'm going to see if I can even turn on my camera. See if that works. Crossing my fingers. Okay. All right. So yeah, so I'm sure all of you are going to go jump. Hopefully you heard most of this from this point. Yeah, no, and somebody said that maybe someone else is streaming from your home. No, okay, I'm turning my camera off. I'm still having trouble. So I kicked everybody off in my home. They're gone. And turned every single device off. So everything's focused using my mobile hotspot. And I'm going to keep it. It keeps kicking off that. Hold on. Oh.
Okay, everybody, sorry about the delay. We've lost our speaker for a moment. I'm sure she's probably rebooting and will be back on momentarily. Yep, I see her there. So I'm going to invite her back in and we'll get that going again.
All right, so I'm hooked up to my phone. Hopefully it won't drop again. And now, am I on? Okay. So anyway, I apologize. I am online all day and I don't have these problems, so I really bear with me, folks. I feel badly about this. I'm going to share my, here we go. Okay. More time. Oh, goodness. I'm really frustrated. It just dropping. I'm going to try a thing. Oops.
Kate, I can hear you now.
Okay, I'm going to try one more thing where I may be able to connect directly to my phone, not using.
Yeah, we can hear you perfect right now.
It just dropping. So, okay. There we go. All right. One for all. Can you see the slide? It looks like you can see that.
Yes.
Okay, wonderful. So I have actually connected my phone directly to my computer anymore. Learning as I go. Okay, so in terms of, okay, so I don't know if you heard, but basically I was saying in terms of conflict resolution, there really isn't. It's a vast field, broad definition. Within that is alternative dispute resolution, which all of you, I'm sure, have encountered in your work. And so ADR is really just a use of mediation and arbitration and any alternative to going to court instead of litigation. So ADR, if you look up, do a quick search for what ADR is, you'll see all kinds of terms, and it's very vast as well, not only within the United States but globally. What the definitions, what fits under ADR. So, there aren't any uniform definitions globally of what ADR means. And some people use ADR as a verb, can you ADR this? But so, how we all use that is going to varies widely. But most of the practices within the field of alternative dispute resolution that we recognize are working with conflict. And the difference between each of these practices is how we engage and what our goals are with the conflict. So one of the questions I get is, what's the difference between conflict management and conflict resolution? Most people want a resolution to the conflict, but one of the things that I really prefer to, I've really shifted toward conflict engagement, because I find that if we can learn how to wisely engage in conflicts, we can, we'll have better outcomes rather than fearing conflicts and wanting to find, closure and come around full circle and finish the conflict, because we know that conflict can fester for a long time and they can be really uncomfortable. So if we can just kind of become more comfortable with conflict, we might be able to ease into an outcome that everyone can live with. So, I've really grown fond of this term conflict engagement, and it's one of the things that I encourage the mediators who go through my training to think about, because if we can all mediators be more comfortable with conflict, we can model that for our clients as well. But at the heart of all of this is negotiation. So really talking about strategies for engaging in conflict, I'm going to be talking about how to negotiate, some of the negotiation skills. So when I talk about simple strategies, this is really from, I kind of pulled from the book, Getting Past No. I don't know how many of you have read that book. It's a wonderful book. And I highly encourage it. It's an important primer on negotiation that I think everybody should read. And so in the book, Bill Urey introduces 5 steps to breakthrough negotiation. And I want to kind of take you through those steps today. So before we go into that, I think it's really important that we all take a step back and reflect on our own reaction to conflict and think about, your conflicts with coworkers or clients or family members or neighbors. You've got all kinds of conflicts. Colin Rule, who started PayPal's mediation program, he said he estimates there are 6 million conflicts every minute, right? So the conflicts are going on around the world all the time. So we have all kinds of conflicts going on. So I want you to reflect on your own conflict number and think about, just keep it private. You don't need to share it with anybody. And then when you think of the word conflict, what words come to mind? So if you wouldn't mind dropping those in the chat. So I see some words: argument, friction, disagreement. Excellent, productive. So I asked this of all the students to go through the mediation course as well. And so I took a snapshot of a recent cohort, and this is what they came up with. So you can set right at the center. So this is a word cloud. So each time a word is repeated, it gets larger. So I don't know if you've ever used word clouds. It's called Word Garden. It's a great little. Goodness.
Sorry about that, folks. I see we lost her again. Let's see if she gets back quickly.
Yeah. This is my all day long, every day, and I don't know why I'm having so many problems with Teams. Use Macs, and so I don't know if it just doesn't jive Mac, but I've just never had luck with Teams. So I use all day, and I never have these problems. So I feel so bad.
It's okay. So, it happens. I've seen this happen many times.
So anyway, I'm going to turn my camera off. I have tried to. Now it just keeps reconnecting to, and I've even turned off my Wi-Fi on my computer, and it keeps wanting to connect to my phone, and even though I have my phone, so and it says that it's a setting in Teams that it's doing it, so I don't know how to do that. So anyway, and I promise you, I've got like the best Wi-Fi that Cox can offer, and it went full on, and yes.
Would it, I know you want to use your presentation, but would it help to just talk through your presentation and not have the slides up?
I don't know. Yeah, I get I feel really bad. I think it's going to be really hard to present, to be honest with you, without the slides.
Okay, well,
and
use the slides.
Like very patient folks, but yeah, I'm feeling really badly about this. It's not it's not good.
All right. Well, let's push it. Let's just push ahead, and we'll roll with whatever happens. Okay.
All right. All right.
You sound great when we can hear you.
You're very thoughtful. Thank you for the encouragement. I appreciate it. I'm going to turn off my camera again, because I think that usually helps with stability. And we'll see. The hard part too is I'm focused on the slide, so I can't see when I go offline until you all kind of disappear. Oh, okay. So I'm going to try one more time sharing the slides, and we'll see how that goes. Okay. So, okay, so here we are. And as I saw some of the chat, you could see that most people's gut reaction to conflict, most of the words are negative, right? Most of us feel fairly, we just generally don't have a positive reaction toward conflict. And most fear conflict. And so this is one of the things that, again, with the new mediators, I encourage them to take a look at their own reaction and then recognize that our clients, and most of you are working with clients who are dealing with some sort of conflict in some way, and so they're coming to the table with a lot of fear and angst, just as we are. Most of us have some sort of negative, fearful reaction toward conflict. So if we can find those strategies for engaging with less fear, it can go a lot better. Much like I'm feeling about this presentation. So the first thing we need to do is go to the balcony. And I liken this to the pause button. So first, somebody comes to you and they're angry, and we have that fear reaction, right? So we want to leave the conflict, we want to escape, and so what if you could just put an imaginary pause button on the conflict and for a moment suspend your own reaction to the conflict. So this is called going to the balcony. And at the balcony, there's so many possibilities. You can spend some time just being really mindful, observing what is going on, your own reaction as well as their reaction, suspending our reaction to the conflict, kind of putting a pause on that fear, recognizing the fear that we have, reflecting on, oh, I've been here before. Why do I feel this fear? Our motivations, for resolving this conflict or not resolving, maybe walking away from the conflict. Do we need to be here? And then recognizing some of the various sources of this particular conflict, and maybe that's where the solutions lie or the problems that we want to walk away from. And finding some hidden gems, maybe there's an opportunity to find some common ground or to present something that we know that the other person wants and needs. And so offering that to them and looking for underlying messages, maybe making assumptions about things that really aren't there. So one of the things that you may have heard of before is this conflict, the notion of conflict iceberg. So usually when there's a conflict, there's a presenting problem. So that's what we see. We see the anger, see the body language, the defensiveness, the arguments, resistance, hostility. And so what we can't see are the things that are driving those reactions, the fear, values, perception, facts, assumptions, and all kinds of many things you can't see. And so there are different ways. One of the things that me do is try to get to understand what some of those underlying issues are in a conflict. Now, and I don't know if this is too, but I wanted to try to do an exercise. Don, we talked about this before. Do you think that it's possible right now? I don't know if I'm still in and out.
I am very hopeful.
Okay. This is a fun exercise. What I need 6 volunteers who will, be put in the meeting room. I don't know if it's the same concept in Teams as it is in Zoom.
Say that again. 6 volunteers that what?
That go into.
Yeah. I'm not sure if we can do that.
Let's skip it. Yep, let's skip it. Sorry about that. We're just gonna keep going. That's unfortunate. It's a really fun exercise that highlights the importance of how we make assumptions. And anyway, I'll just go past that. So the next strategy is really stepping to the other person's, the opponent's side. And one of the ways we can do this is distinguishing between positions and interests. So what understanding of what a position interest, what do you think is a position?
Could you ask that question again? What was the question?
The question is, well, I'm just going to go ahead. So, the difference between, I was asking if, what's the difference between a position and an interest? So a position is what people say they want, as I want to be right. I'm really important. I want it my way. I want you to listen to me. I want you to get out of, I want you to ignore my strengths. So that is the difference between the position and the interest. The interest, or that's the position, sorry. The interest is what people really want. So what people really are for is stress. I don't want to feel this fear and this stress. Or maybe I just want excellence, and I'm afraid the way of that excellence. Done. I want to feel good about this. Oftentimes what gets in moving forward is people present their position instead of their interests. So one of the things that we can do in terms of dealing with interest is don't count what the person is saying. We're tempted to say, don't get so upset. It's going to be okay. Two is don't avoid their. We're not here to just. Instead, do the unexpected to acknowledge them. This is one of the things that negotiators often do, and you can do this without anyone giving in or giving up by simply acknowledging somebody is looking for what their interest. Really, it's one of the greatest listening skills. They often will say, "I feel heard. I feel acknowledged," and by acknowledging them, wanting to step to their side and show some understanding. Problem with interests is they aren't always. So you got this look at a glass of water. One says it's half empty, the other one is half full. But there can be another interest, another concern by looking at this. So the third gentleman says, what on that doing there without a coaster, right? So there's an interest, and we oftentimes will assume that there are only two. So if we can ask open-ended questions, and I'll talk about that in a little bit, we can get to those underlying interests. So the next strategy is don't reject, reframe what the person is saying. And one of the things that I encourage mediators to do is to, whoops, does somebody have their hand up?
I do.
Oh, sorry.
Well, I just, before you went on to that next one, I wanted to know if maybe you could share, and I know you don't do divorce mediation anymore recently, but for divorce, in your experience, what are some typical position versus interests with, parties that are, that have children, let's say, or just property issues? What are some typical position versus interest scenarios that you've seen?
Well, I'll give an example of a couple that was, they were divorcing, and the mother had told the father, they had been living next door to each other, and the mother had said, okay, I'm okay with you. He bought a house next door. This was a post-decree, so it was they had been divorced for a few years, and she had said, look, my husband, she had remarried, my husband and I have an agreement that after 2 years, we're going to move to the state where his other children reside. And the father had said early on, verbally, I'm okay with that. Well, then when it came to her actually making the announcement, okay, now we're moving to this other state, the father said, no way, in fact, I can stop from taking the kids out of state. So he knew this was, an option for him. So in mediation, his position was no way. But when we started exploring what it was he actually wanted, he broke down and started crying and said, What I really want is to make sure my kids know that I went to bat for them. I want them to feel like I gave up on them. Mother started crying and said, how can I make that happen? I'm willing to figure out a way to find this that our kids feel like you did go to bat for them. And in fact, I'm willing to come up with a plan that allows you to spend more with him than they currently do. Even though the father lived next door, he traveled quite a bit. And he had kids, and he admitted that he hadn't. So in the end, his real interest was, I leave a legacy for my children that give them comfort that mom and dad went to bat for them. I don't want them to feel like I abandoned them. And so that was a really deep, kind of hard to frame interest, right? How do you put it into writing? But once we could explore those interests, right, you know, kind of like, what on earth is that doing there without a coaster? Kind of, you know, you ask this broad question, then we could come up with, and it was a complex agreement, a simple agreement. And so anyway, that's a great question, Dawn, and that to me, that's an example of how the interests don't jive. You know, they're so vastly different from the position. The position is there's no way, and in fact, I have the right to keep them here, and I want to exercise my right. The father didn't care whether or not the kids continued next door to him. He just, his main was, let's see.
Thank you.
Yeah. Sorry, I missed the hand. I just kind of in the corner there. So, so when it comes to, it was, you know, using that, I'm just going to build on that example that I just gave of, you know, father wanting to present something. He wanted a solution that said to his kids, dad went to bat for you, gave up on you. And part of him was a guilt he had that, you know, even though 2 years he'd been living next door to the kids, he'd kind of frittered it away, really didn't spend as much time as he should have. And the mom felt like, I gave you every opportunity, and you games. You never went to, you know, their concerts, that sort of thing. And so instead of rejecting what he was saying or rejecting what the mother was saying, because, you know, there was a good chance that if that dad had gone to court, he may have won, but but he also knew that everyone would have lost, right? Because yes, the kids would have been forced to stay in the States, perhaps, but would that have been the best solution? And he didn't really the best solution. It wasn't the best solution for his ex-wife, who he wanted to maintain a relationship. He had a fairly good parenting relationship, so wanted to maintain a sense of peace and stability for the kids, which he felt could happen if they moved out of state. And it was at a time when I think the oldest one was about to start high school, so they felt like it was the right time. And they had children with special needs, and they found a school that would have really met. So anyway, instead of rejecting, what we did was admit in terms of listening to the interests and how can we meet those interests, and now frame it in a way that everyone can live with this. And one of the things that you can do is asking I statements. And you know, it's funny because children learn I statements. My adult children, my sons are all in their now, learned them at school, but I was never taught this at school. So, you know, this is probably familiar to many of you, but maybe not all of you. So an I statement is, I feel. These are, you know, really soft skills. Feel, you name the emotion. In this behavior, and then describe the effect on you, and then what you need, and that's where you get to that interest. So, for example, when my sons, a year ago, my sons came home for the holidays. I've got 3 boys and they're 12. They come home and we spend a little bit of time, and then they're friends because they're all have gone to school out of state. And so I feel the whole week disappears and I don't really get to spend time with them. And then they'll stay out late with their friends and they'll sleep past noon, and then, you know, they'll grab a quick bite and go out with their friends again. And so I tried using an iMessage with them, and I said, you know, I feel disappointed when you sleep past noon because I haven't seen you in a while, and what I need is vacation so we can spend some time, you know, quality time together, and you get to spend time with your friends. So once I framed it in an I statement, instead of you guys never spend time with me, or you're always out, you know, instead of a you statement, once I did that, that became our patterns. Before they, in fact, this last Christmas, my sons did all come home again in spite of COVID. We managed to do that. They quarantined even, but we started a shared note on our iPhone. We planned our time together, so we were all on the same page. So just really having that discussion, they recognized that my interest was sure we optimized our time together, and that they got their time with their friends as well. It was a little easier with COVID because they couldn't really see a lot of their friends. So
Kate, can I give it a try?
You bet.
Okay, so I since we're relating things a little bit to family law, so would an I statement be something like, I feel angry when you're late for exchanges. It makes me feel disrespected and I can't plan the night with the kids. I need you to call me at least 30 minutes in advance.
Brilliant.
Okay.
That's a great, it's a great example. Yeah, and what happens oftentimes in an I statement, people will take an I statement. Yours was brilliant, Don. And what happens a lot is people will say, I feel that, instead of I feel angry, or I feel frustrated or disappointed. If you go to I feel that, it ends up being a you statement. So I feel that you never call me. I feel that you are always late. So if you confuse that, it's really easy. Now, the order of the I statement doesn't really matter. You can say, you know, when you are late, I get frustrated, you know, that sort of thing. So it can, you know, the order of the I statement doesn't really matter. The important thing is that it's an I statement. It's not a you statement. You're not pointing the finger, because a you statement really moves into the position, you know, late. You're not here. You broke the agreement. And instead of, and what I need is, and that's proposing a solution is really getting to the underlying interest. And with that, you can't negotiate. If you don't tell the other person what it is you need, you can't really negotiate. You don't have anything to negotiate. You can't negotiate options. So one of the things that we do, kind of building on what you said, we can help clients craft I statements by asking the questions. So instead of don't reject out what they need, so you can help others by making those I messages for them by asking, so how did it impact you? How did you feel? A lot of times we cringe at saying, how do you feel? How did that make you feel? It sounds very touchy. How do you don't like to use that? Or if it sounds very canned, you can say, how did that impact you? Or what's your reaction? And when does this happen? What is the pattern? What causes you to feel that way? What are some of the other causes? And then finally, and what do you do to not have that reaction? So it can help you really identify and recognize the human, irrational, irrational side. You know, that we are human beings, right? We are dealing with human beings, and we can't predict people, and so we can't make assumptions what our underlying interests are. It's really easy to make assumptions because we think we know, we anticipate, especially if we're talking about something about a long relationship, whether it's a coworker or a neighbor. We assume we know what their interests are because of the patterns that we might have established between them, and so really draw them toward agreement by helping them frame a you message into an I message. So again, don't reject, reframe. So don't reject the other party's position. You're going to become defensive and unwilling to negotiate. So acknowledge the intensity without being defensive. For example, the new policy creates pressures on your person. I can't change the policies, but let's explore other options. And then show understanding, demonstrate empathy and or agreement. So I can see that my decision has really affected you. You can borrow from their words and ideas. So it sounds like rush hour traffic is stressful. Neither of us wants you to come to work feeling tense. What are some solutions? Reframe negatives, get creative, piggyback on ideas. Your idea about moving to a different area may be as crazy as you think. No promises, but I'm open to brainstorming solutions. Then brainstorming. The next step is really building them a golden bridge so that they understand your side, your interests. You've now some time listening to their interests, and if we're talking about negotiating, you need them to ours as well. Now this requires some empathy, and if you haven't had a chance, I would encourage you to look up, and I'm going to put it in, there's a wonderful 3-minute TED Talk, 3-minute version of a TED Talk by Brene Brown on empathy with this, you know, if you, let's see if I can get to the chat. No, I'm not seeing it. Here we go. Hopefully you got that. A TED Talk about empathy, but really empathy is one of the best ways to conflict. I could spend all day just talking about the importance of empathy and conflict resolution. I'm going to jump past that just in the interest of time. But one of the things to also, another way of bridging understanding golden is through the way we ask questions. So asking the right questions. So most of us aren't very good naturally at asking the right questions. We tend to ask closed-ended questions. So closed-ended questions, what are closed-ended questions? So I put that out to all of you. So closed-ended questions are questions that you can only answer yes or no, right? So really say this. Agreed. Did you talk to your boss? Don't you get it? Yes or no, right? So I want to, let's see if we can try this. This is another exercise. If you've played 20 questions before, then this will be familiar to you. I'm going to play this 20 questions, and I'm going to think of something, and you need to guess what it is. And you may only ask closed-ended questions. And I need somebody to tally and let us know when we've hit 20.
I'll do it.
Okay, thanks, Don. So, and I'm thinking, let's see if the best way to do it is through chat or unmiking or unmute. I'm not sure which.
Say again, Kate, what was your question?
My question is to ask these questions through chat.
I think using the chat would be good.
Okay, perfect. So, all right, I've got it. So using the chat, see if you can guess what item I'm thinking of.
Are you providing any clues at all?
Nope, you have to ask yes or no questions. Is it an object?
Okay, Kate, I don't think we heard your answers to the question. Is it alive or is it an object?
It is not alive and it is an object.
So is it your house or is it a house?
Is it a house? No. Is it in my house? Yes.
So it is in your house.
Yes.
Go ahead. Anybody wants to ask more questions? Okay. Is
In
it
my
your
office. Yes. Yes.
Is it your phone?
No.
The computer?
No. Is it in my? No. Does it have power?
Does it have power?
Is it my bookshelf? No. My printer? No.
I'm sorry, did you say it has power?
No.
No power. Okay.
And
Is
it is not my bookshelf and it is not my printer.
Is it
Desk?
a pen?
Desk? No. Pen? No. My pet? No.
Any other guesses or questions?
Where are we, Don?
I'm not sure if I took great count, but I think we're at 15.
What is it made of? What material is it made of?
Oh, that's not a closed-ended question.
Is it made of wood?
No.
Is it made of metal?
No.
Is it made of glass?
Yes.
Is it your cup?
Yes.
All right.
Okay.
Woohoo!
I believe that was the 20th question.
All right.
Signing up for the new LP program.
Wonderful. Well, so one of the questions that you asked was an open-ended question, right? So it was not a yes/no question, more of an open-ended question. So with questions, you start with what or how. So what did you mean by that? How does this impact you? What do you need? How would you like to handle it? What do you propose? Or tell me more about that, right? So open-ended questions, you can get a fuller answer. So now I'm going to play 20 questions again. And I'm going to think of something else. And again, you need to guess. This time you may only ask open-ended questions. So, okay, I've got it. Now you may only ask open-ended questions. Okay, Don says, tell me about the object. The object is something that I use for writing. It's blue.
Would you hold this in your hand and make marks on paper?
That's a closed-ended question.
Oh, all right. Yeah, right. All right. Thank you for that. It's before 11 o'clock, so my brain is slowly engaging.
Oh no, don't worry. That's part of the exercise, right? How often do I use it? I use it probably a couple times a day. I'm gonna give you a hint. You can ask one question and probably get the answer.
If I took this from you, would you be unable to write?
That's a closed-ended question as well.
Oh,
and
sorry
also,
about that. All right.
Shereen asked, does it have different colors, which is also a closed-ended question. Okay, Jennifer, you win. What is it? That is an open-ended question of questions. What is it? So one of the things, the purpose of this exercise, and don't those of you who ask closed questions, because the purpose of this exercise is to show that we naturally tend to ask closed-ended questions for us to ask. What happens when we ask closed-ended questions, it takes many questions to get an answer, whereas a question is right to answer, right? So, which one is your right? Those closed-ended questions, you had no problem getting that questions. Now, one of the things I tell mediators going through my training is when in doubt, because then they often, oh no, I'm so afraid I'm going to ask the right question, is when in doubt, said that I'm mute. Whoop. Can you all hear me?
Yeah.
Okay, it's a minute. So I'm not sure how much you heard. So one of the things that I like to tell mediators if they get kind of overwhelmed, like I don't know the right questions and I'm afraid I'm going to ask the wrong questions, is to listen. And one of the things my grandmother, who passed away a couple years ago, used to tell me is just remember, there's a reason the words listen and silent have the same letters. That's a picture of my grandma Rose there. Listen and silent have the same letters. So if you don't know what to say, it's okay to just be silent, leave some silence there and really listen to what the parties are saying in order to, instead of focusing on the right open-ended question. But the best way to ask an open-ended question is, again, remember to start with what or how. That's easy. What or how instead of do or will, should. Closed-ended questions, start with did you, don't you, do you. Open-ended questions, what or how. So finally, strategy is bring them to their senses, not to their knees. Oh, Don, you had a question.
Well, I just wanted to make a comment that, and I'm sure everybody realizes this, but these skills that you're going over, these are critical in our business as a document preparer. One of the big things we do, we're not always helping, mediating matters between clients, but we're doing a tremendous amount of information gathering. And that information gathering may be relevant to, really law, setting up parenting plans, and maybe relevant to estate planning and finding out what's really important, what their underlying interests are, and doing certain things. And, and those are all so important, so we can do what they want, and we can help them realize whatever they're seeking. And that's true whether you're doing family law, estate planning, probate, civil law, whatever the case may be. So I just want to emphasize the importance of these skills in our daily business. So that's it. Sorry.
Oh, thank you. Right, and one of the things that when people will take, a lot of times people will take the mediation class and they'll say, I'm not even sure if I want to be a mediator, but they come out the other end saying, oh my gosh, these skills are so important. And, the listening skills. And this is one of the reasons why I love presentations and I love teaching, because I'm also a mediator. Obviously, I work directly with clients, but I find that the more I teach it, it's a good reminder for me of how important it is, not only in my personal daily life, where it's easy to forget, right? It's easy to forget these things, but with my clients, modeling them and listening. I mean, listening is key to being successful, helping our clients find their own successes as well. So one of the things, and this is a negotiation term. I don't know how many of you have heard of the term BATNA. Has anybody heard that before?
No. Yes.
Do you remember what it is, Don?
Best alternative. I'm drawing a blank. I just say best next alternative, but best alternative to negotiated agreement. Best alternative to a negotiated agreement.
Right, best alternative to a negotiated agreement. And I remember when I first learned the term, another mediator in the course that I was in said, I'm just going to always remember of a bat in order, like a baseball player, to remember BATNA. But yeah, what happens if no solution is reached? And this is a really powerful. So it helps our clients do some reality testing, right? So if you end this today, if you say, I want to go to court, instead of trying to work out a reasonable negotiated agreement, what is the best possible solution for you? Go that route. If you walk away from, from the negotiation, what do you maybe a judge will make the decision for you. That might be good. It might not be. It may work out well for you. But oftentimes our clients don't always know what the BATNA is. We might be able to help them explore the BATNA. Knowledge of the BATNA can be a source of power. One party may know the BATNA, the other one may not. So for example, the couple that I talked about, the father did some homework. When I talked about the father who realized that he had something over the mom, the mom knew, she didn't think that he knew that he could keep the kids in the state. So she was just kind of forging on with her plans. He came to the table, you know, you can't take the kids out of state without my agreement. And I've decided I don't want you taking them out of state. And so, you know, if he had stuck with that, like I said, it would have been lose, lose, lose. You know, the kids would have lost, dad would have lost, mom would have lost. And instead, when they took a look at that, that's the best alternative to working out something that might be a little more complex, but everyone wins. Let's spend some time on that. It was really, they hugged one another. You know, it was a very emotional. I think as many mediations are, it was emotional. The solution was brilliant. Anya, have your hand up again?
Yeah, me again. Yeah, no, I just wanted to share too that, you know, as a document preparer and, you know, in recent years as a court conciliator, you know, I every day just about I mediate little decision making, parenting time agreements between people. But and this is, I've used this in other areas as well. But you know, I think this is the most powerful tool, you know, for a mediator to use or a negotiator to use, because I tell people I in my opening with people, I always explain that, you know, this is an opportunity for the two of you to keep control of the court orders and not just leave everything in the hands of the judge. And that's not to disparage the judge at all, but you know, it really is the court's position too, that the parties involved, they're in a better position. They know what's going on with their lives. They know what's going on with their children, and they're in a much better position to craft what those orders should look like. And as you say, the alternative is that you go to court. And along with that comes a lot of uncertainty, a lot of stress, a lot of headache, a lot of time, a lot of money if you're paying attorneys especially. And so I find bringing that up a couple of times throughout you know, throughout either a mediation or even if it's just during an information gathering session, that can be very powerful in helping people come to agreements and encouraging them to work things out.
Yes, absolutely. Obviously, you know, over time, I've been a bit of a zealot with mediation. So I'm so, the success rate is so high, you know, when people mediation, you know, and we're not supposed to say what our agreement rates are, but I just can't help how I get so excited about it. When I ran the attorney mediation program, you know, at the AG's office, where people in many cases were ordered to go to mediation, they didn't really have any option. Ours was 91%. 91% of all the cases that went to mediation resulted in agreements. And then 99% of the people that participated in mediation, regardless of the agreement, ended up satisfied with the process. So maybe they didn't reach a full agreement, but they were happy that they attended me because they were enlightened. They knew more. Oftentimes people realize what their own interests are through mediation. They come in not really understanding what their interests are. They're really focused on their positions, but if you can move positions to their interests, and if they have an agreement, they feel better about the outcome, even if it does end up going to court or, you know, gets litigated somehow, or that go to arbitration. So it's kind of building on what you were just saying, Dawn, and your plug of mediation. One of the things that, again, with family mediation, that what I like to do is, and I, like, as you said, I don't do family mediation, but I do a lot of mediators that are going into family mediation, that are mediating family cases, is to foster of a team. So I took this from, I don't know if you've ever read the book, The 5 Dysfunctions of a Team. And if you haven't, it's over a weekend. It reads like a novel. It's a story of a dysfunctional team. And, but dysfunctions, what makes a team function, this is really what people in conflict need to be aiming for and recognize. So I'm sure many of these elements will make sense to all of you. So the first one is fostering trust. if you can help the parties understand and hear others' interests and bridge that understanding, it's a way of, again, bringing them to their senses and not to their knees. If you can help them build trust, even if they don't trust everything, if you can build trust around an issue or around a part agreement, you can help foster trust toward the end, a final result. You might say, that's okay, you don't have to fully trust this individual, but you can trust the agreement. And then seeing conflict as opportunity. So when I put the word conflict out there, some of you, saw some positive. You had some associations that were positive, and oftentimes that is a positive. There is an opportunity there. Conflict can provide some gifts, right? Understand one another a little bit more. You understand you're enlightened about your own interests. And commitment to decisions. And that's the beauty of, again, coming up with some sort of agreement is it really is you are memorializing your agreements and committing to some decisions, maybe not all. And mediation, the agreements aren't about all of the issues the parties brought to the table, but they can commit to some decisions and hold each other accountable for delivering them. So in a mediation agreement, we will generally go through the who, what, when, where, why, and how, all the details of the agreement, who will deliver what, when to one another. And then focus on the collective results. So rather than, I often say that mediators, one of the things in our field is our goal is mediocrity. It's not necessarily perfection. We oftentimes want everybody walking away happy, and usually what they walk away with is, I can live with that, it's better than what I came in with, but not what I was hoping for, but I can live with that. I can walk away with that, and the people in my world will support me because whether it's my spouse or my coworkers, they can support me because I'm in a better place. So finally, just kind of a say is just really review the potential costs of conflict. What if this conflict continues? What if you win? What if the other person wins? How is this going to affect the broader community? Whether that's a family, the broader family, extended family members. If we're talking about family mediation, we know that when two people divorce, it doesn't just impact those two people. It impacts the effects are reverberating. So, what are the potential costs of festering conflict? Also, we can't push the parties. Threats will backfire. If you hold the BATNA over them, that can backfire. State the facts. You can frame the BATNA in a way that's not in a threatening way, but just the factual way, reality testing. Review mutual gains and show them, going back to show them the progress made. So, you turn lemons into lemonade and focusing on the resolutions. And so, unfortunately, we didn't get to a couple of the exercises that I really wanted to do that may round out this presentation. So we're ending a little bit early, but I am so happy to answer any questions that you might have. And again, my sincerest apologies for the technical issues. And finally, I want you to, if you think about it, write down, I said from 1 to 10, and I'm curious if anybody's number went up. So Rob, you hand.
Yeah, I'm wondering maybe you could tell us if, when we're referring clients, especially in family law, or if those who have civil practices, if there is something we should look for in a mediator when we're trying to find kind of a network of mediators to refer people to.
Mm-hmm. Oops. Great question. I would say McAfee is a great resource. Are you familiar with McAfee? The County Association of Educators.
I'm not.
So McAfee is a great resource here in I don't know Valley, but in Maricopa County at least. Although there are many people beyond Maricopa County that I think it's statewide. Many, and I don't know if there are other associations in other counties, but I know mediators now. I'm just off the top of my head that are part of that association that aren't necessarily in Maricopa County. But in terms of what to look for in a mediator, obviously the mediation training that they've had basic mediation training, because there are many people who will offer mediation services because they'll say, well, I've been doing mediation for a long time, and without a deep understanding of what mediation is. A lot of times we think that if we've been giving two people advice and we've been in a neutral role, that we've been mediating. And that is not mediation. As Don can tell you, mediation is not giving advice except with respect to the process. So you can do some interviewing of mediators, find out if they've received the basic 40-hour mediation training, and then are they good listeners? That's, I would say, essential. Do they have these negotiation skills? So hopefully that answered your question. Angelica said, could you, go ahead.
Okay, if I could just add to that, a lot of people are, I mean, the training is essential, but do you want to comment? I don't know if you have an opinion one way or another, but about the benefits or differences that you might find between a mediator that maybe has a law degree versus somebody that has. Before I even ask a question, I should probably say. Mostly, and this isn't across the board, but mediators that you find out there are either going to be lawyers, or they're going to have some kind of mental health background, like in counseling, or there are some out there that were just specifically trained in mediation that don't have either. Do you have any comments about when you might want to look for somebody that has a legal background versus a mental health background or otherwise?
One of the things, I have quite a few attorneys that go through my mediation course. And one of the things to say is they spend so much time unlearning what they learned or unlearning what they were practicing all those years as an attorney, that the skill set is so different, so vastly different. It's quite the opposite of being an advocate for your client. You're an advocate for the process of mediation. And I know that sounds very cliche, but it's really, you're really connected to the process of mediation, and the process is getting those ends and helping the parties explore best possible solution that they, the mutual gains. So in terms of, does somebody need to be an attorney? What I hear over and over from these is, in fact, many of them struggle. I mean, there are excellent attorney mediators, so that you shouldn't, that attorney mediators are better or worse than non-attorney mediators, but many of the attorney mediators will say that they really struggle to wear both hats, that they really want to take off one hat and just do one or the other, if that makes sense. So
absolutely. Yeah. You're talking about the importance of being neutral and the difficulty that some attorneys might have. It's not just attorneys, but in advocating for one party or the other. But the other thing, kind of along that line, would you mind commenting a little bit about the different types of mediation facilitative versus other types, and what normally you might see out there?
Right. So there are various frames of mediation, and the fast, it's growing all the time. Right. There are there are three main frameworks. One is facilitative mediation, and that's what, if you've ever used a mediator, or that's the most common mediation framework. Facilitative mediator is committed to facilitating a process. So as a facilitative mediator, the only advice we'll give is with respect to process. Take a call now. Could you restate that? Did you hear that? I'd like to ask so and so this party a question. So facilitating the process, but within that falls within actually what's called the problem solving model. So the is problem, and a problem solving mediator, obviously their goal is to solve the problem. I mean, and it's easy to think, well, what else will a mediator do? But bear with me as I break this down. The problem solving model is a facilitative mediator, and another type of facilitative is an evaluative mediator. And many of you have encountered an evaluative mediator. Many attorney mediators practice evaluative mediation. Many mediators who are maybe content experts, they hire them because of their expertise in law or in contract disputes, and so they will give some additional advice beyond just process, but they will give advice with respect to content. Advice, if you don't reach an agreement, you're going to see Judge and about Judge Smith, as Judge Smith is going to typically rule in this favor or in this way or that way. So additional advice that they would give the parties based on their content, based on their expertise. Another framework is transformative. So Don, I think that's what you're asking about, is facilitative versus transformative. There's a book called The Promise of Mediation. I have it over at my bookshelf, where it's a promise of mediation and recommendation of a book. The Promise of Mediation is a great book. I recommend it because it lays out these different. It goes a little deeper than what I can do here in a couple of minutes. A transformative mediation really doesn't give any advice whatsoever. And in fact, I'm trained as a transformative mediator because I'm a mediator for the U.S. Postal Service, and they all their transformative mediation. And so as a mediator, I can tell the parties where they
say that again. You were breaking up. I don't know if you want to turn off your video. Maybe we can hear you better for a moment.
Oh, we'll do that. Okay. So as a transformative mediator, I'll give an example of when I mediate for the U.S. Postal Service. I don't even tell the parties where to sit. So I will open the door and say to the parties, this is where we're mediating, and they choose where they're going to sit. Whereas as a facilitative mediator, I'm going to sit in the middle. I have one party on one side, one party on the other side, or I have them sitting side by side, just kind of depending on the type of case. A transformative mediator lets the parties choose where they're going to sit. And the power dynamic is part of the process. So their own processes, I don't intervene in their processes, because what transformative mediators believe is that the parties' own processes are part of their conflict. So maybe the way they communicate, maybe the way they exercise power, rather than me trying to level the playing field, they recognize their own processes that are getting in the way of their conflict. So maybe one is speaking over the other. And another thing that a transformative mediator does is not just reflect what the party is saying, but reflect it with the same intensity. and volume. And I have to say, I'm uncomfortable doing that to some extent. As you can imagine, when somebody's yelling or cursing, you know, as a transformative mediator, we're supposed to reflect that back and restate what they're saying with the same level of intensity. So even though as a mediator, I'm somewhat uncomfortable doing that, the results are, the success rate of transformative mediation is even higher than facilitative mediation. And the parties really appreciate, they feel even more validated and more heard than in a, you know, facilitative process. And then the third framework, so we've got facilitative, transformative, and then the third framework is organic mediation. And organic is pretty much kind of everything else, right? So if you are somebody who are, maybe you are mediating within a congregation. So you're a member of a church community, a faith community, and the minister knows that you're a mediator, and the minister comes to you and says, hey, we've got this conflict. Would you be willing to mediate? However, I want to make sure that it's done within the context of our faith community. So that is one example of organic mediation. So there, maybe not all the same rules apply that would apply in facilitative mediation. As an organic mediator, I may need to follow some of the organization's rules. Maybe there would be some sort of blessing or prayer that would be said at the beginning. Maybe everything isn't confidential. The agreement takes into account the broader community, not just the parties that are in a conflict. So another example of organic mediation is within an organization, within a company. So if the mediator is a manager and is mediating between employees, the agreement may not be confidential. It may not be a written agreement. It may just be a temporary solution. So the rules are somewhat different. So those are the three main frameworks. And I know that's like, you know, Don, I could talk all day about that. That's a long answer to your question.
No, I appreciate that answer. The other thing I think it may be important for this group to comment on is just kind of the difference between, and maybe I should just I'll comment on this and you correct me or add to it, but just talk about court mediators, you know, for a moment in family court, for example, with court mediation. Or I guess let's talk about family mediation, private versus the court. And with the court mediator, and I know Rob's going to talk about this in his presentation about family law a little bit. He's going to refer to conciliation services, and so the court in conciliation services offers mediation services. And in fact, for those of you that practice family law know that most parenting plans require mediation before you go and try to modify something, or at least at the same time. And I just wanted to comment that the mediators there, you know, they practice facilitative mediation. I'd say the success rate is very good, but maybe not quite as high as private mediation. And I would say that the reason for that is not necessarily that the mediators aren't as good. The reason, I think there are multiple reasons. One, probably the biggest is the time factor, is that people attending mediation through the courts, through conciliation services, there's a 2-hour time limit on the mediation. Whereas, you know, if you've got, a complex matter and that needs to be mediated in private mediation, you can have as many sessions as you want. And so I think it's important to know those differences. And obviously the cost would be a big difference. You know, mediation is for a nominal fee with the court, whereas I'm not even sure how expensive it can get in private mediation. Any comments, Kate, about that?
Yeah, and I think maybe another factor, and correct me if I'm wrong, because you're doing this, Don, is the voluntary nature. When somebody hires a private mediator, for the most part, they're choosing to do that, and so the two both parties are have a level of commitment to that, and they're paying, right? They're paying on an hourly basis. And so I find that when most of the cases that I do these days, like I said, is in the public sector. I work primarily with universities, colleges, and then government agencies. So the agency is hiring me. And one of the difficulties I find sometimes is the employees aren't necessarily there voluntarily. So I have to spend some time really bringing them to the table. They feel like they've been ordered to mediation. And when people feel pressured or ordered to mediation, there's resistance and it takes a little bit longer. So I think when people I think the success rate is going to be high. As you said, the time factor, when they have more time, when people don't feel pressured and they feel like they made this decision voluntarily, they're more likely to reach an agreement. And oddly enough, too, the less pressure I've found that parties feel, the quicker they reach an agreement. So the more you push people and speed them up, their resistance goes up, and the time frame, to reach an agreement will go up.
Right, and don't get me wrong. I by the way, I totally agree with about the voluntary nature or involuntary nature of the mediation. But don't get me wrong, with the court, we still have a high percentage success rate.
Right.
But it's still, I doubt that it's as high as in the private sector. But it's probably, depending on the mediator, certainly over 50%, more like, maybe 60, 70%. So it's definitely, and it's, but yeah, time can definitely be a factor. And the other thing is that, even with cases that I mediate, for example, where I don't always help them come to an agreement there in the session, I think a large percentage of the cases that we don't end up having time to write up a final agreement, because of the work we've done in mediation, they end up resolving it anyway. And I, maybe I'm fooling myself to some extent, but I'd like to think that that's because of that process, not in spite of it.
I think you're right. When I was doing family mediation, I co-mediated with a male attorney. So we had a male-female team, and what we called parking lot agreement. So after 2 hours, the couple spent, we'd be done for that. The couple worked with, still out in the parking lot, worked their agreement. They feel good. They learned a session and some of the skills they gleaned from mediation, and they felt like they could reach an agreement. And they would call us the next day and say, "We're ready."
Right, absolutely. Okay, so what else? Oh, the only other thing, I don't know if you, and then we can wrap up this segment if you'd like. I do think it's valuable to comment a little more on the confidentiality, the confidential nature of mediations. We've touched on it, but people might not be aware. I mean, the rule is, with mediations is that they are confidential. So what's talked about in mediation, it's kind of like the old Vegas, what happens in Vegas stays in Vegas. With mediation, what happens in mediation stays in mediation. So if people mediate, if they, whatever's said there cannot be repeated in court or in any other forum for that matter, it's all confidential. And hopefully I think that makes many people feel more comfortable that they can maybe make suggestions and discuss things that they might not otherwise discuss or suggest in a non-confidential forum. And if there's no agreement, then that's it. Yeah, well, like with the court, for example, there's just a notice of no agreement submitted. Doesn't imply fault on anybody's part. It's just that's it. And so, but confidentiality of mediation, I think, is very important. I'm sure there's other reasons that it's important that Kate may be able to expand upon.
No, you're right, Don. The confidentiality, I find that it puts people at ease. They realize that because it's confidential, they can really put all their cards out on the table pretty early in the negotiation, if that makes sense. So you don't have to hold everything back. You can just start there. And that's one of the things I tell people in the opening statement is because this is confidential, because everything you say here can't be repeated, in court, can't be, what you can start with your bottom line instead of trying to work toward that. And that puts people at ease. They realize, gosh, this is not going to be a terrible waste of my time if I can start there. And then if, when people start at their bottom lines and they're, oftentimes a little shocked with the other person, but we start exploring those underlying interests, how did you come up with that? And that's where the confidentiality really can be useful because oftentimes there's some sort of hidden issue, or they had a different set of facts, or there's some insecurity that they really don't want to, they're afraid to expose. But if they let the other person know, for example, the husband that I talked about, where he said, I'm really worried that my kids aren't going to think I went to bat for them. So if they can put that out on the table early on, then you can find a way to work around or work with those underlying issues.
Okay, Kate. Well, if you do you have anything you want to wrap up with? Certainly, please share your information. If there's any people that are interested in exploring, possibly, taking any of your courses or becoming a mediator themselves, you want to talk about that and in your wrap up?
You bet. Yes. So the mediation course that I offer now, just by accident, at the end of 2019, I had a group of people overseas that asked me to teach them a mediation course. I was actually supposed to go visit them, and then it got canceled because of it was in Kenya, and there was a lot of conflict, ironically, in Kenya. Because of the conflict, the mediation training got canceled, and the State Department wasn't going to let us go over there. So this group asked us if I would conduct the training online. I was very hesitant. I didn't think it was possible. But fortunately, we put that all together November 2019. And then, of course, the pandemic happened. And ever since then, we've got, as I said, about 173 mediators now going through the program completely online. So it's a 40-hour course, but it's self-paced. A lot of the content is self-paced, and then you actually would practice live with mediators from around the world in 1 hour. Like you would do in a regular course, it would be, a role play simulations. And we've got family cases, we've got business contract cases, all kinds of cases based on real mediation cases. Practice in these, and I have coaches from around the world that are coaching people, and we've got we've got sessions all throughout the week. So anyway, the course, a normal mediation course, when if you Google what a mediation training would cost, the typical cost is anywhere from $1,000 to $2,000. I think AAA charges $2,000, and so because I'm running this online and I'm still, completely rolling it out, I'm able to offer it at a much lower rate. The course itself right now is not open to the general public, but I sent it to, let's see, I can put it in the chat. So if you go to that link, imamediation.com/AAIP, you can not only find the handouts, but you'll see that I've opened it up for all of you. If you're interested in enrolling in the course, the 40-hour mediation course, or if you've already taken a 40-hour mediation course, you can message me. And we have an advanced course called the Master Mediator. So it enables people to just keep practicing, building those skills. One of the problems with a lot of mediation courses is they just teach the 40-hour training, but they don't help people get clients, mediation clients. And so that's one of the things we're working on, is helping people really build their mediation practice, get clients, and keep building their skills as a mediator as well.
Okay.
So thanks. I hope that answers your question. Thank you so much. And I appreciate
Absolutely.
everyone's patience. And I really appreciate this opportunity to present today.
Well, Kate, we appreciate you coming to speak with us. You're always welcome. Hopefully soon we can get you in person for, another in-person seminar sometime once this COVID thing is gone. But yeah, I mean, definitely everybody, if you're looking to improve your skills, as an interviewer, in what you do in your daily, life as a certified legal document preparer, or augmenting your services and becoming a mediator, Kate is a great place to start with that. As I mentioned, I took family mediation training, a 40-hour course from Kate way back a long time ago. Back in, I don't know how long it goes. It was a long time ago. But it was a great place for me to start, and I highly recommend it. So that will wrap up this part of the seminar. And I again thank you, Kate. And I'm gonna take back the spotlight here, and we'll move on towards the next and final leg of our webinar. Thank you again, Kate.
Thank you, Don. Take care.
Okay. So, I see a message. Can we get the PowerPoint slideshow? I think Kate posted in the chats a place where you can click on, you can go and download that information. So if anybody has a problem with it, just email me and I'll see if I can, I'll probably download the stuff and have it so I can forward it to people as well. But she left something in the chat to do that. I should turn on my camera. Okay. All right. So it is time for the second word of the day. And so you want to be sure and write this word down so we can, in the end, after the webinar is done, remember this is the second of what will be 3 verification words, and you just need to email that to me, and then I'll send you your certificate of completion. I see somebody that dropped out that's trying to get in. Let me get them in real quick. Okay, and again, this is the second word of the day. The word is pizza. So P-I-Z-Z-A, and get everybody hungry for lunchtime, which is coming up pretty quick. Can I turn on my camera? I did turn on my camera. Hopefully everybody can see that. So again, the word is pizza, the second of 3 words today. All right. So we are going to move on to our third and final presentation of the day. The presenter is Rob Merrill. Rob is a certified legal document preparer. And Rob is going to be discussing, I should have misspelled it, yeah. Sorry. Rob is going to be speaking to us about family law basics, and then also what's not so basic, information about quadros and related information. So I'm going to make Rob put the spotlight on Rob, and we'll proceed from there. Okay, Rob, take it away. And you need to unmute.
All right, my sound okay? My microphone working all right?
You're looking great.
All right. So, well, I'm happy to be here, happy to share some insights with you, and hopefully get some good information out of this. Wanted to kind of give you a couple pieces of background about me before I kind of get into the basics of this. And I'm going to open up my PowerPoint here real quick. And should be working. There we go. Can everyone see the PowerPoint okay?
Yes.
Okay. And so just a little bit about me and who I am and what I am, because a lot of you don't know me. I am Alan Merrill's son, youngest son, and the most handsome of the children. They finally, after 10, they finally got it right, so they decided to stop. And I came into the business about 7 years ago with them. I had spent about 12 years in banking prior to that. And part of the reason I came into the business was I just got kind of burned out on banking, and he was thinking about retiring, and I was thinking about doing something else. So I decided to get into this business with him and see if it was something I enjoyed, and I really did enjoy it. You know, my biggest problem with banking was I always felt like I was selling debt to people and selling them things that they didn't really need. And so when I got into this business, I really felt like I was providing a service that people needed and wanted, and it was helpful, but also able to make a living for my family. So that's kind of why I got into it. I spent 12 years in banking. I spent 7 of those as a bank manager for M&I Bank and BMO Harris Bank, and which some of you might be familiar with. I've married, I have 5 kids. Our oldest is 16 and our youngest is 5. And they are great kids. They're all home from school this week because I'm at my office with COVID. And so I'm going to be committed to the nut house by the end of this week, working from home and having all 5 of them at home going to school online. So I updated my mental health care power of attorney so my wife can take care of that. And like I said, I have 12 years of banking experience. I've got an Arizona real estate license as well for about 15 years. I have a bachelor's degree in accounting from WP Carey at ASU. And kind of the areas that our business focuses on is estate planning, family law. We do some real estate documents, deeds, notes, promissory notes, deeds of trust, those types of things. And we also have a tax practice as well. I put my contact information on there as well. So in case you have any questions, I'm happy to answer any questions you might have, and give me phone calls or anything like that you might need. So kind of what I'm going to want to talk to you a little bit about today is family law and some of the basics of it. And the reason I want to get into the basics is I feel like sometimes in this business, there's less opportunity to get into new areas. And so it can be kind of intimidating to get into a new area if you don't have those resources to do that. And so I wanted to go over some of the basics. So for some of you that do family law, this might be a little bit repetitive, but for those of you who may be thinking about expanding your practice a little bit, we're hoping that that will give you some insight and some resources where you can do that. And then we're going to go over the process of divorce and some of the other processes of other family law issues, some child issues that come up and some things to think about with that. And then the basics and not so basics of contested matters, real property issues that come up in family law and divorce and modifications and things, some of the tax issues with divorce. And I'm going to talk a little bit about quadros. And for those of you who don't know what a quadro is, that's a qualified domestic relations order, which is required to divide assets or retirement assets in a divorce. And then I want to talk about some best practices for family law and just practice in general in that area. The other thing I'm going to touch on a little bit, I was thinking about this last night, was we talked about a year ago about these PPP loans and some of the other stuff that's going on there. I'm going to touch on that just briefly at the very end to kind of follow up on a couple things that have come up that I've seen in our tax business and payroll stuff that might be helpful to you as document preparers. Doesn't really have anything to do with family law, but I thought it would be a good thing to touch on. So couple main areas, a couple of main resources for family law for people who practice that or who are looking to get into it. It is governed by Arizona Revised Statutes, Title 25. It is a very long section of ARS, and it's very helpful to read through that and make sure you understand exactly what's in there. So I included the link that's directly to that, to those statutes. Also, the Arizona Supreme Court rules of family law procedures are really good to have on hand. I keep both of those bookmarked because every once in a while I'll come across something or a client will ask me a question and I need to refer back to those. That Westlaw website for the family law procedures is very user-friendly. It's really easy to find information on it and make sure that you're staying in compliance with those laws for your clients. And if there's something that comes up that maybe you don't understand or don't know the process, that's a really good way to do that. That is a very detailed breakdown of those laws. So if there is something you're looking to learn about or you're not sure about, that gives you very good explanation of it. So let's talk about the different types of family law documents, mainly documents. These are documents that I prepare on a regular basis, that we do all the time. And so there's obviously other stuff that comes into this, but these are the main ones that I think probably most of us are doing, and especially what I do. So the types of proceeding: dissolution proceedings, which is commonly referred to as divorce, where we're dissolving the marriage and dividing up assets and debts and maybe dealing with child issues. The second one is legal separation. I don't do a lot of legal separations. I figure I do about one a year, if that. It just doesn't come up very often. And basically that is, we're not dissolving the marriage, but we are dividing up assets and debts, and they're going to live separate financial lives and maybe even separate lives with the children, but they are going to remain married. Modifications to child support, modifications to parenting time, legal decision-making, spousal maintenance. We modify decrees fairly often, not super often, but pretty periodically we'll modify decrees by stipulation. And terminations, and I put support, not people. The court will not terminate your spouse. And so terminating child support, spousal maintenance, those types of things. I think we got someone with a hand up here, and so trying to make that work. And so, Carl, do you have a question there? Maybe. Am I hearing anything? Okay.
No, I don't see anything, Rob.
Okay. Someone had a hand up there. So, okay. So we'll keep going. And then paternity. When I was going through this, I was thinking, I always think of paternity because it's usually the father that's the one initiating these things, or possibly the mother, but they also have a category for maternity. So I always thought that was a little bit funny. There was always a funny scene in a movie I used to watch as a kid called Mafia, where it's a kind of a comedy movie, and the main character introduces the son to his former wife, and she's surprised that she has a son. I always thought that was kind of funny with maternity proceedings. So let's talk a little about the basics of divorce and dissolution and what we're dealing with in general, and hopefully we'll get some stuff out of this. And so if you have any comments on that, or you have any experiences or something you want to share or best practices, please feel free to raise your hand and we'll do that. So we're talking about the basics of divorce and dissolution. Now, when I say divorce, generally I'm going to include legal separation because the processes are very, very similar. In fact, they're almost identical, with one small exception. And so when I'm talking about divorce, please include legal separation in with that. So we're talking about the division of assets and debts. And this is governed. So the first statute we're going to look at is ARS 25-3018A. And essentially what that says is that Arizona requires that the division of assets and debts be equitable. So what is the difference between equitable and equal? Well, equitable, as the court has interpreted it, and in the rule, it basically says that it is essentially equal, but not necessarily in kind. So what does that mean? It means that we're not necessarily dividing everything in half. And how I describe that to clients is when they ask, well, how does it have to be done? And I say, well, it's got to be equitable, but not equal. So I mean, so if you have two clients that each have $100,000 retirement plans or IRAs, you don't necessarily have to divide both IRAs. You can say one gets 100,000, the other one keeps theirs, the other one keeps the other one, and that's an equitable division. Or, for example, if one of them has a $200,000 plan and the other one has a $100,000 plan, you could simply divide one of them and save a little bit of money and just equal out the two plans. So it doesn't necessarily mean cutting the baby in half and making sure that the division of assets and debts is equal. It's that the end result, that end number of what assets and what debts each party obtains are essentially equal. Okay. And that can include things like the value of spousal maintenance or other types of assets and debts that could come into play with the divorce or the legal separation. The other issue one of the other common issues we're going to deal with is spousal maintenance. Now, in my practice and most of my clients, we don't see spousal maintenance really to be an issue, or what used to be called alimony. But it is something that gets addressed fairly often, and so something we'll talk a little bit about here, and some of the issues with that, some things to be aware of. And then if there's minor children involved, we need to deal with the minor children. And there are three separate and distinct issues that need to be dealt with a divorce or legal separation with children. That is, first of all, is what's called legal decision making, which used to be called custody. And so who is making major decisions for the children with regard to health, schooling, life choices, things like that, whether that's going to be joint or sole, if both parties are going to work together or if one party is going to make those decisions. Also, parenting time. Now, the important distinction there with legal decision making is that joint legal decision making does not mean equal parenting time. And that's, I think, an important expectation to set with customers and clients, that just because they're doing joint legal decision making does not mean that they're going to have equal parenting time. And the last thing is child support. And child support is a separate issue. However, it is tied to parenting time, because the parenting time will have an effect on the calculation and how much child support is paid by one of the parties. So, so next, what documents are we going to file? What documents are required to be filed with with those documents? So the first thing that's going to be filed is petition for dissolution or petition for legal separation. The summons, the preliminary injunction, the credit notice, and the notice regarding health insurance. These are required no matter what in every single divorce case and every single legal separation case, with the exception of the health insurance notice on legal separation, because if they're legally separated, they can actually still keep the same plan together for health insurance. So that is, and I'll go over these kind of what they do and why we use them. And then if you're going to if you have a dissolution or a divorce with children, you're going to add a parenting plan in there, whether that's joint or sole legal decision-making parenting plan. An affidavit regarding minor children, which simply establishes the facts of the case, and generally, or facts regarding the children. Generally, what this is used for is to make sure the court can establish jurisdiction over the kids, and I'll explain that in a later slide. Also, the parent worksheet for child support, which is commonly referred to as the child support calculation. So this is what we're providing the court, saying this is what we think the child support should or would be. And then the last thing is the order and notice to attend parent information class. This is, in my practice, is the thing that causes the most problems, not because it's overly complicated, but because the parties forget to do it. And I'm constantly reminding them that they have to do this prior to their hearing, otherwise the judge will not order the divorce. And so this is something that in the communication part of this, I'll kind of address a little bit more, but essentially it's a class that they have to attend. It's about 4 hours long. It's all online right now, costs $50, and essentially teaches them how to parent, what the court expectations are, how to deal with conflict between the parties. It's not necessarily a parenting class per se. It's more of how to parent in a separation environment and how to make that good for the kids and good for the parties. Any questions or comments on that? Feel free to raise your hand on that. I want to go back to those first documents and just kind of explain those real quick. This is kind of how I explain them to my customers. Is the summons is basically outlines the method for responding and the timeframes for responding if one of the parties disagrees. Preliminary injunction is exactly what it sounds like. It's a list of stuff that the parties are not allowed to do. Commonly, can't hide assets, you can't harass the other party, you can't take the kids out of state without the permission of the other party or the court, can't run up a bunch of debt, those types of things. And then the credit notice is something that's very important. Something that came up often when I was a banker too was the credit notice essentially says that even though one of the parties might be awarded debts or be ordered to pay certain debts, that the creditors are not a party to the divorce. Therefore, the creditor can still pursue both parties, even though one of them has been ordered to pay the debt. Some creditors will honor the divorce. Most probably won't, because they want to be in the best position to recoup that debt. And the last one is the notice regarding health insurance. Just gives the respondent or the other party some information about what they can do to keep their health insurance plan, and that if they're covered under health insurance by the petitioner, and it gives them the rights and procedures for doing that. So next is some other documents that are going to get prepared regularly. Now, I prepare all of these documents at once. Some of you have heard of Hot Docs, and some of you use Force Trust Software's trust templates. Those are all done in Hot Docs. And Hot Docs is simply it's a construction. It allows you to construct templates that will merge into Word. So you can build a questionnaire type system that will merge into a form document that you have created in Word. It is a complicated and also simple process. So I've built some of those divorce templates for us that we use. So I prepare all of the documents at once just to save some time and be able to pass that time saving on to my clients. And so some of the things that I prepare with every single divorce that I do an acceptance of service. I do a certified mail affidavit in case that comes up. I do an application or affidavit and application for default, which is almost certainly going to come up in most of our cases. Probably about 85 to 90% of our cases go through the default process. And then also I immediately have the decrees made and the addresses or the envelopes that are going to go along with that. So hopefully that gives you maybe some best practices there that you can use to save some time. The next thing is some other documents that might come up is temporary orders. And temporary orders are simply interim orders to the final decree. So you have the petition that comes up, and in a default process, you're probably right now, if you hit all the deadlines on time and none of the parties puts up a fit about anything and your client does what they're supposed to do, you're usually about 60 to 90 days from the beginning to the end of the process. And so in that interim time frame, there may need to be, or if it's a contested matter, it could go as long as a year or two, depending on what the situation is. And so in the interim time frame between petition and final decree, there may need to be things like spousal maintenance order. There may need to be child support order or legal decision making and parenting time that needs to be in place so that the parties understand what they're doing. Don, did you have something?
Well, I don't want to interrupt your flow. I had a question about the prior stuff you were talking about, just about the information gathering process before you're preparing all those documents. You kind of briefly touched on it, but what do you use to gather information from parties? Do you have a specific questionnaire that you use? And I just wonder if you'd talk about that process.
Sure, we do have a questionnaire, and go ahead, sorry.
No, that's it.
We do have a questionnaire that we use and that we can use, and we actually have our questionnaire built into Hot Docs. And so I'll go through and interview the client. We'll sit down and I'll kind of set some expectations, and I'll get into this a little bit more in detail in a later slide, but I'll set some expectations about the process, and then I'll kind of go through and ask them all the questions. And so we'll talk to them about, these are the things that we're going to ask about. When I talk to them on the phone to set the initial appointment, I tell them kind of, here's the things we're going to talk about. We're going to talk about the division of assets and debts. We're going to talk about some tax issues that are going to come up on that. We're going to talk about alimony or spousal maintenance. If there's kids involved, we're going to talk about the parenting time. And I kind of set the expectation that they need to have specifics in mind when they do this, especially if they're in agreement with the other party, which happens fairly often in our business. And some things that I always joke around with clients and I say, everyone comes in and they say, oh yeah, we know exactly what we want to do, right until they start talking to me. And then I'll ask them questions about what they want to do that they haven't thought of. And so those are pretty consistently parenting time, specifics on parenting time, income information for child support calculations, whether or not there's going to be spousal maintenance, how they're going to deal with primary residences and other real estate, those types of things. So we go through that questionnaire that's built into that. But we do have a paper questionnaire as well that some people prefer to take home and fill out, and we allow them to do that as well. And
when I was just wanted to comment that, for those of you that are considering getting into family law and maybe, offering these type services, the questionnaire, just like any type of service, I guess you could say, it can be really critical. And I think it's always wise, and this is the way I was trained, that the rule of thumb is to really encourage people to be as specific as possible when with all this information, which I often found some resistance to that. But in other words, with property and debt, assets and liabilities, don't just say. Say something. If you have a house, you have a car, you have a bank account, don't just rely on the idea that you have already worked that out with your spouse. You need to say specifically what you're doing, how you're specifically dividing up those debts, for enforceability reasons and just, organizational reasons, but mostly for enforceability reasons. And I was just wondering, could you comment on those? What do you find resistance or difficulties or with getting people to give you that information?
Yeah, no, that's a very good point, and I do have that every once in a while. We get a lot of times where people will come in and say, "Oh yeah, she's just we just want to make this real simple, and she's gonna keep what she has, and I'm gonna keep what I have." Well, that doesn't really work real well. And so I go through that questionnaire. If I'm doing the questionnaire on Hot Docs or whether I'm doing it with the paper questionnaire, I'll go through it in detail with them and say, and I kind of set the expectation. Look, I know you want to make this as quick and easy as possible, but you also want to make sure this is as specific and enforceable as you can make it. And I actually have them sign this will be in my best practices later, but I have them sign a thing at the end when they sign their documents, their initial petition and everything else, that says that they have reviewed the documents word for word, and that they have read it, and they're in agreement with what's in there, and that they understand that everything that is in that document is potentially enforceable by the court. And that also says that they understand that if something is not in that document, it is potentially unenforceable by the court. And usually when I tell them that, at the very beginning of the process as well. And usually when I tell them that, it kind of sparks a little bit of interest in their mind and says, okay, maybe I need to be a little bit more careful about this rather than just cramming this divorce through the process, thinking I'm going to make it through that. And so when I do that information gathering process, I go through and say, do you have bank accounts? You have joint bank accounts at this point? Are they separate bank accounts? How are those going to be handled? Do you have, I'm not looking at my questionnaire here, so it's kind of hard to go down my questions, but do you have vehicles? Do you have retirement accounts? Do you have pension plans, which we'll talk about a little bit later? And there's a difference between retirement accounts and pension plans. And it's very important to note those differences. Do you have personal property that you want to make sure you get? Is there real estate involved? Do you have any long lost real estate? Do you have, I talked to him about, do you have real estate that's only in one party's name? One of the problems that we run into fairly often is we'll get through this process and they go, oh yeah, I have another house, but it's just in my name. Well, and you'll see later on some potential issues with that. So I go through and go very detailed over each and every kind of category of asset that could possibly be out there, and then I ask them, is there anything else that you're aware of out there, and then debts and things like that. Does that answer your question, Don? Is that kind of what you were looking for?
Absolutely. Thank you.
Right. And so I think we kind of went through some of those, and I'll get some of the specifics of that. And so I want to kind of get into the temporary orders, like I said, of how those work. And temporary orders, like I said, are just the interim orders for these types of issues in between the original petition, meaning the opening of the case, and the final decree, which is the final order that divides everything up and sets up the legal decision making and child support and all that kind of fun stuff. So there's two types of temporary orders: the with notice orders, which is by far the most common and probably 99% of what we do when it comes up, and then the without notice, or what's called ex parte or emergency, or commonly referred to as emergency temporary orders. So with notice is obviously pretty straightforward. It's just you're notifying the other party. You'll usually serve the temporary orders along with the petition and the other documents on the party. And you typically within 30 days, the court will have a hearing, or 30 to 45 days, usually the court will have a hearing on those orders and make temporary orders if it's needed. The without notice ones are a little bit more complex in that they are governed by Rule 48 of Arizona Family Law Procedures. And every time I do emergency temporary orders, I go through this rule with the client to make sure they understand exactly what they are asking for. And there's one particular line in that rule that is critically important, and that is the justification for temporary orders without notice, meaning you're not notifying the other party that you're asking the court to do this, or that they're so important they need to be ruled on before it would be reasonable to notify the other party. And that means that the other party will be irreparably, or that the petitioning party would be irreparably injured. There'd be irreparable injury to a party of the case, which could include children. Their loss or damage would result that would be unrepairable, essentially. Or, in my interpretation of this with clients is, generally there's an immediate risk of injury or death, or there's some other really, really, really good reason for it. And it's got to be darned good. The court is because you're essentially violating the civil by ordering ex parte orders, or orders where the client has not had, the other opposing party has not had a chance to respond to them. You're essentially violating their civil rights. And so there has to be a darned good reason to do that. And so usually I tell people it's, unless there's immediate risk of injury or death, and what the definition of emergency is, and set that expectation, because their definition of emergency varies a lot from what the court's definition of an emergency is. Any questions on that? Any comments on that? Maybe issues that some of you who've practiced family law have family law documents where they've some issues that you've seen come up in that. Okay. And you can raise your hand if that ever comes up, and feel free to interrupt if I'm going too fast, or if you do have a question or a comment. So the basics of temporary orders. First of all, we get this question all the time, and that is, well, I just want to do temporary orders. Well, you can't just do temporary orders. You have to file temporary orders with a petition for permanent orders. So meaning you have to file it with the petition for the divorce or whatever else, what other matter you're doing, whether you're doing a paternity or maternity or modification of child support or something like that. There also always has to be a petition for permanent orders. In uncontested matters, meaning the default process, where one of the parties isn't responding or doesn't respond or doesn't want to respond, or the parties are in agreement, they might never be ordered. And the reason for that is if it's temporary orders with notice, meaning it's not an emergency, there might not be time to order them. You know, that process can be pretty fast as long as the court's not super bogged down with COVID stuff. That process can actually be pretty quick. And I had one where I had a guy who wanted temporary orders, and he was having all kinds of problems with the spouse, but there wasn't a dangerous thing. She was just a very stubborn person and just would not comply with some of the things that we were asking for. And so we asked the court for temporary orders, but by the time the judge even got to them, the application for default had already been filed. And so the judge just said, look, there's no reason to do temporary orders because I'm going to make permanent orders on this because she hasn't responded to it. And so the judge never actually ordered the temporary orders. Whether that was proper or not, I don't know, but it worked out, and it was just fine for him. And I kind of warned him of that before that. I said that's a possibility that could happen, and so he was okay with that. And so, yeah, so that's kind of what we do. And so temporary orders, like I said, you gotta be careful how you file or what they're filed with. I really like using the court forms on those. The judges or the judicial officers are very familiar with the temporary orders through the self-service center. And so I use those. I don't use the court's forms for the petition or anything like that, but I do use their temporary orders. They're pretty good documents from what I found. Okay. So let's talk about the basics of property division. These are generally the three statutes that govern property division in Arizona. So the first thing you have to remember about Arizona is that Arizona is a community property state, meaning everything that is acquired during the marriage is part of our community assets or part of the marital community, meaning essentially each party owns half, if that's how you want to describe it. And that's assuming there's no prenuptial agreement or premarital arrangement or postmarital arrangement for that matter. There are some exceptions to that, and so we can talk a little bit about that. Exceptions to the community property laws are, let's see here, I had them written down. Things that are inherited property. This are the inheritances, things that are gifts, things that were acquired prior to the marriage of the parties. And that can be a sticky little thing. And so that's some things that we'll get into later on. But that's essentially some exceptions to the community property. It's not an all-inclusive list by any means. And then there's the separate property laws. And essentially what I just said, stuff that's acquired prior to the marriage or items that a spouse has disclaimed or waived their marital property rights on. You see this pretty often in real estate with what's called the disclaimer deed, where one party might be purchasing a home and the other party disclaims that interest to the buying party or to the party purchasing the home and says, I don't want any community interest in it. It's their home, sole and separate property. And there are some issues with those as well that we'll talk about when we get into the contested matter issue. And then issues about debts. Here's kind of the funny thing on debts, and there's an odd, if you read that statute, that is a very good statute to be very familiar with, because everyone assumes that community debts in Arizona, that the other spouse cannot be held liable for separate debts, and that's not really true. Community assets can be used to pay separate debts, or can be used to, a creditor can use community assets to collect on separate debts. But only to the extent of essentially the debtor's half of the community property, or the debtor's contribution to the community property. So it's something to be aware of and something to make your customers and clients aware of. Arizona is not a common law marriage state. It does not recognize common law marriage. In fact, technically in Arizona, cohabitation with a member of the opposite sex is a misdemeanor. Obviously, it's never enforced because it's horribly unconstitutional, but it is technically a statute. I remember when I was a kid, Jane Hull was the governor, and the legislature had put forth something to repeal that particular statute, and just out of principle, she wouldn't sign it, which I thought was kind of funny. But it is not a common law marriage state, meaning it is not a state where just because you live together does not mean your assets fall under community property. So some of the other basics of property division: dividing retirement plan. The language in this is critical. And you have to be aware of two different types of retirement plans. There are defined benefit plans, which are commonly referred to as pensions. What that means, it means based on your salary or your years of service, you're given a certain monthly or annual benefit from the plan, and that continues for life. It might pass on to a spouse, which is kind of if in the event that the retiree is deceased. And so that's something very critical to be aware of. Also, defined contribution plans. These are things like 401ks, IRAs, 457Bs, 403Bs, all these other types of plans that are out there. Basically, it's you've contributed something, you put in a certain dollar amount based on your paycheck, and that grows based on your investments. Military retirement plans and benefit, or what we call death benefits. This is a whole different ballgame, and you can really get into the weeds with military retirement. If military retirement is an issue where there's a large pension or survivor benefits or things like that, generally I refer them to an attorney to get advice on these, because it can be hugely complex. And it doesn't sound that way, but it is. It can be, I should say. Not always, but it can be. So it's something to be very careful with and very aware of. You need to be aware of I'm not going to get into that because I could probably spend 2 hours just talking about military retirement benefits and death benefits. Kind of moving on, if there's no questions on that one. So spousal maintenance. When is spousal maintenance? So commonly referred to as, oops, did I skip it? Commonly referred to, what used to be referred to as alimony. And this is the statute ARS 25319 that governs when spousal maintenance is appropriate. I've kind of set that there's about 8 different reasons in there. These are the most common ones I found, is that there's insufficient assets or income for the other party to support themselves, whether that's petitioning or the respondent. The care of a child, especially like a special needs child, makes employment unreasonable. Or perhaps that you have made some significant contribution to the other party's education that maybe has damaged your ability to make money or to earn a living. That can be something that comes up. Or you have a long-term marriage where age makes employment unlikely. So let's say you have 2 parties who got married when they are 75 and they're getting divorced at 95, which sounds funny, but I've seen happen. And it's not likely that one of those parties, and those other issues apply too. Maybe one of the parties doesn't have income, or they're living off little or no Social Security. That's where spousal maintenance might be important. And the spousal maintenance calculations are not set in stone. There is the statute kind of outlines some things for the court to consider. I was Googling online just to see what I could find on those. And I found a bunch of attorneys' websites who had spousal maintenance calculators. These are essentially, they might give you a good guideline, but they're not really useful in the sense of there is no specific formula for spousal maintenance. It is very subjective. It is based on the arguments of the parties and based on the income of the parties, the assets of the parties, all these other conditions that go into play, and they are not set in stone. It's a very subjective type calculation that the judge is going to make based on a lot of different factors. Enforcement to it is very similar to child support, except that failure to pay child support is a Class 6 felony. Failure to pay spousal maintenance is a Class 1 misdemeanor. And so there are, in theory, criminal penalties for not paying spousal maintenance. Don?
Can parties agree to a specific amount of spousal maintenance? Can it just be stipulated without any issue?
Yeah, so if the parties are in agreement to it, you can do a specific amount. You can do it for a specific period of time. You can do it indefinitely. You can do it forever. You can do it, there's lots of things you can do with spousal maintenance where the parties can agree to it. And a lot of times in our practice, that's what we see. Usually if there's spousal maintenance being ordered, a lot of times they've already agreed to it. One thing about that is if there is an agreement, there can be a provision in there that the spousal maintenance is unamendable. And so you have to be careful about that particular thing and what the terms of that are. And usually the spousal maintenance will terminate at either the death of the paying party or the other party or the receiving party, the remarriage of the receiving party, or by order of the court some way. Do you have something else, Don, or is your?
Yeah, how, if you would, how does the spousal maintenance that's ordered end up impacting child support, if at all?
Yeah, it can, but usually they are two separate calculations. Now, you have to remember too, the court is going to take into consideration, if one of the parties is paying $2,000 in spousal maintenance to the other party, or paying $2,000 in child support to the other party, and they make $5,000 a month, the court can't require them to pay an additional $2,000 in spousal maintenance. So that calculation will get taken into effect. And it can decrease the amount of income. And when you do pay spousal maintenance, it decreases the amount of income that's used for the child support calculation. So it can affect that. Is that what you were looking for, Don?
Yeah, and there's another question I see in the chat about how to modify spousal maintenance. And actually, before you answer that, my understanding, I mean, when I used to calculate child support, there is a line item specifically for on each side of the sheet, one for who's paying spousal maintenance and who's receiving it. Is that different now? I haven't been doing child support in a few years.
You mean on the support payment worksheet?
Yeah, on the worksheet, right.
Yeah, it decreases the paying spouse's income and increases the receiving spouse's income for the purposes of that calculation. So
okay,
it is on there. I kind of neglected the chat, so let me kind of maybe.
Okay, and I see somebody else has their hand up.
Yeah, go ahead.
Mary.
Okay, so can you hear me?
Yep.
Okay, so it used to be that there was a tax consideration also. Sometimes the parties would say spousal maintenance was income to the receiving spouse and a deduction from the spouse paying the maintenance. Is that still an issue?
Well, it is an issue for spousal maintenance that is ordered prior to 2019, so 2018 and earlier. So the tax reform bill that passed in 2018 essentially made it that alimony has no effect on the taxes of either party. So it is not tax for orders that occurred in 2019 and later. The alimony is not deductible to the paying party, and it's not taxable to the receiving party. Okay.
Excellent. Thank you.
For ones prior to 2008, for when spousal maintenance was ordered prior to 2019, that is still an issue, and it is still an item on their tax return. So it's important to know when that order took place.
So if they go in to modify spousal, and would that be considered in the 2019 tax, or because the was before that?
The tax code says that it was initially ordered.
Okay.
So as long as it's the same person, and it's the same party and not like a separate divorce or something like that, then it will always remain in that tax bracket depending on when the initial order for spousal maintenance was made.
Okay, thank you.
Good question. So Angelica asked the question, can an LDP use the court forms to assist the client? Yes. Answer to that is yes. Can spousal maintenance be modified? Yes, it can be. It just depends on the circumstances. Like I said, sometimes there is an order or a stipulation in there or a clause in there that says that it cannot be. I always tell people the court can do whatever it wants for the most part. And so sometimes even that won't stop it. But for the most part, it can be. Usually if there's a major change in income and that particular provision is not in there, there's a major change in circumstances. The receiving party gets married. The receiving party or the paying party dies, one of the two. Those are some circumstances where spousal maintenance might not continue, or simply by agreement by the parties. Sometimes the parties just agree, okay, you know, we're willing to stop this and move on. So that can happen too. And then spousal maintenance, like Alejandro said, spousal maintenance does affect child support, like we talked about. So, so if there's a comment that comes up, let me know. Sunny, did you have a question or a comment?
I don't, sorry, just accidentally touched on that. Sorry.
Oh, okay, great. All right, so, let's see, I kind of lost my spot here. So we're on spousal maintenance, not set in stone. Okay, enforcement. And we'll talk about enforcement of these things a little bit later. So, so the next thing is basic. So some things we've already talked about, equitable division, like I already said, not necessarily cutting the baby in half kind of thing. Some things to think about that come up in pretty much every single case for the most part, real property, primary residences especially, retirement accounts, pensions, vehicles, personal items, mortgages, credit cards, tax debt is one that comes up that I didn't put on there. Tax debt's a really important one to deal with, those types of things, okay? One thing that I think is really important that I'll talk about in the tax issues, but it kind of fits in here too, is that when we're preparing these documents, is that tax thing can be a real sticky problem, where the parties may not know that there are other tax debts. If you're in the tax practice, you know that the IRS, if you make a mistake on your tax return or you have unclaimed income or something like that, the IRS is not fast at dealing with those things. And you might get a notice from the IRS saying you've got unclaimed income or unpaid taxes 2 or 3 years down the road after the divorce has happened or after those taxes are due. So it's important to address those issues in the petition and the decree as to what happens if that becomes an issue. Because if not, then the parties under the statute, the parties are just equally responsible for it, and that might not be what the parties want, and it might not be beneficial to one of the parties or your client. So it's something that really needs to be addressed in, I think, every single case. And anyone who has a tax practice can attest to that particular problem. Let's see here. Enforcement of property division. So this is something that I set the expectation with clients up front so they understand property division and debts, how they enforce it. It's enforceable and collectible pretty much exclusively as a civil judgment. And this is for things like who's going to get what property, who's going to pay what debt. I'm not talking about spousal maintenance or child support here. So because it's a civil judgment, it can be very expensive and it can be difficult to collect on it. The same rules apply to civil debt collection as it does on this stuff. And so that's something your client needs to be aware of if they're trying to say, oh, well, I'll just collect it from them later, or I'll go after them if they don't pay it. I'll just take them back to court. It's not quite as simple as that. There could be things like liens against property needing to be filed, garnishments against wages, and that can be a fairly complex and expensive process. So I set that expectation with them in the initial intake that's something that needs to be dealt with and that they need to be aware of. I kind of touched on some of this stuff already. Legal decision making, whether it's joint or sole, all that means is how they are going to make major decisions for the children. Joint means they're going to work together on it. Sole means that they are going to do it separately, and that the legal decision-making type, whether it's joint or sole, does not affect parenting time. That's a completely separate issue. So it's just a different thing. So one thing that comes up fairly often, and there's an Arizona State Supreme Court case on this, and I thought about this morning as I was kind of doing my final review of this, and forgot to put the court. I'll have to look up the case, but there was a fairly recent Arizona State Supreme Court case that basically said that in some of these legal decision-making plans, especially joint ones, there was a provision that said parties will work together, but this party has final say on everything. And the Supreme Court said that's not appropriate for a joint legal decision-making plan. That essentially makes it a sole legal decision-making plan. So what I've seen recently is a lot of things where there's specific issues where they have said, okay, for medical decisions, party A is a doctor, so he's going to have the final say. And from what I've seen recently, the court has generally been willing to go along with that. What they don't want in there is something that says on all issues, this person has final say. And because that essentially takes it from joint legal decision-making to sole legal decision-making. One quick thing on that, on joint, is if there has been significant domestic violence in the relationship, and that's what the statute says is significant, and that's an objective definition for the judicial officer to make, that joint legal decision-making cannot be ordered. In fact, the statute says it shall not be ordered, meaning no. So if there's been significant domestic violence, then you cannot do joint legal decision-making. And that's something that has to be attested to in the petition. Don?
Yeah, just to expand a little bit about what you were saying about legal decision-making. You described it, you have an excellent description of it, basically relating to educational major, and I emphasize the word major, legal decisions regarding education, health, and then also religious upbringing. And as it relates to education, typically you're dealing with school choice. That's the biggie that most people have if there's going to be an issue. And then also it can relate to issues like, let's say little Johnny is in 5th grade and the school says little Johnny's a genius and he can skip 5th grade. That would be a major decision that would be made by the parents. Another example would be little Johnny is, has some challenges and maybe needs to go on an IEP or go into some type of special education. That would be a major decision. And then, other types of major decisions as it relates to health would be choosing a pediatrician, a dentist, an eye doctor, or making a decision about, a significant course of treatment. God forbid a child has a major injury or illness, and you have to make a decision about the course of treatment. That would be a major decision. And then as it relates to a religious upbringing, typically the options are either A, we agree that either party can take the child to a place of worship of his or her choice when the child's with him, mom or dad, or B, religion is not a factor, or C, we agree that the child should be raised in the blank faith, the Mormon faith, the Catholic faith, the Christian faith, or Jewish faith, and so on and so on. And then with all of that in mind, the options are, as you put it very well, the sole legal decision-making or joint legal decision-making. Joint legal decision-making requiring the parties to communicate and make a good faith effort to come to a mutual decision. And that good faith effort would probably include considering the other party's position, looking into other issues that the party might bring up. Like, for example, if the issue is school choice and mom wants school B or A and dad wants school B, that mom needs to look into school B and dad needs to look into school A. The point is, though, ultimately is that they have to come to a mutual decision or no decision can be made. And the options from there are to go to mediation, or I guess petition the court for the judge to, help out. And, in my experience, typically the judge is not going to make a decision for parties. The judge is going to say, all right, I'm going to appoint mom or dad to make that decision. But the judge is not going to. So parties should really think twice about going there. But then, so that's joint. And then you can also have, and I didn't hear you mention this, the joint legal with final say. And so there was some dispute back and forth over the last couple of years about whether you can have final say, but we're back to doing that. So joint legal decision making with final say, meaning that you really have joint legal decision making the way I just described. But after that good faith effort fails, then so and so is giving that final decision making authority. I just wanted to clarify that. The ins and out of that and the final say aspect of it.
Yeah, and I kind of touched on that a little bit. Maybe I can make that clear enough. But yeah, I appreciate that. Appreciate that, Don. And child support. So parenting time is not determined by the legal decision making. Like I said, that's just who's going to have the children when. Now, I tell my clients, customers, that they need to be very specific on this. And I tell them, you don't necessarily have to be perfect in abiding by it if the parties are in agreement. The court's not going to send the cops to your house because one party said, hey, is it okay if they come at 8:30 rather than 8 o'clock? And the other party says, yeah, that's fine. The court's not going to have someone spying on you to make sure that you abide by that. But what I tell them is that legal decision-making plan, or that parenting plan, that parenting time in the parenting plan, is what's enforceable by the court. And it's the only thing the court will enforce. And so if the parties come up with some other agreement on the side, the court is not going to enforce that. So that's why it needs to be specific as to how that's going to be enforced. And I get down to the point where I say, okay, what time, if you're going to have the children every weekend starting on Friday, what time are you going to have them? And I might say, the respondent is going to have the children from after school during the school year or at 3 o'clock in non-school year times until Sunday at 7 p.m., at which point the respondent will take the children to the petitioner's home or meet at a neutral site or something like that. And we get specific into the holidays. Which holidays are which parent going to take and when, and what are the time frames on that? And so you can get this is probably, in my opinion, a big chunk of the work that comes into divorces with children, is determining that particular thing. Don, did you have your hand up again, or is that from the last time?
No, sorry.
Gotcha. Okay. Child support, the calculation is set by statute, and parenting time is a factor in that. And so there is a child support calculator on the Supreme Court website that you can use. One best practice on that is make sure you're using the right year. There are 3 different years on that. So if you're doing a calculation for a new order